Yes.
Is like listed last day, my lord. Same seat shall be listed. It was supposed to be listed on after 4 weeks.
Okay.
On Monday, my lord. Next Monday.
26.
May it please your lordship. Lordship, with the consent of the petitioner, lordship, I beg to mention item number 15, lordship. Can it be taken up after a week, lordship?
15.
Yes, lordship, item 15. Case for the
It
petition.
may be taken up on Friday. There is urgency because on the ground of disabilities he was not appointed. But
Lordship, I am yet to receive my instruction, lordship. That's why I take for a
already-
week, lordship. I need to file my affidavit as well.
on the last
You have not filed your affidavit?
No,
no,
lordship.
no.
Then how is it coming up?
Last
Oh,
sum
this
was
is admission.
after.
So how much time you want?
Lordship, I just need a week's time, lordship. Can it be on 29th, lordship?
Okay, let's. Heard MS R. Devil and a counsel for the petitioner on request made by Mr.
The Upamanya.
D. Bamanial and standing counsel.
Health.
Higher education.
Lordship,
list on
health and family welfare.
health and family welfare. List on. When do you want?
Lordship, 29th.
Okay.
Highly obliged.
29.
I have an outline test after
Oh.
regarding this matter.
Hmm.
It was last it's in the month of September.
Hmm.
But it has been solved.
Okay.
But yet not listed.
1st March.
Right, Mr. Lordship.
Hmm.
Lordship, I beg to mention for listing on admission matter, my lord. Next week, any date, my lord.
Next week is a difficult. 1st March.
I'm up.
Hmm. Item 26. Yes. For the day. The mic is on.
Okay.
Yeah.
For today, Lordship. Lordship may fix any other date, Lordship, as per Lordship convenient.
You are appearing on behalf of?
Petitioner, Lordship.
Okay, on request made by MS N. Nirula.
M. Niruti.
Then counsel for the petitioner. List on. When do you want? March.
March after 10, Lordship.
Yeah. 14th March.
Obliged.
May it please your lordship.
Hmm.
May it please your lordship. I beg to mention this item for listing for writ petition regarding regularization of the petitioner service.
Hmm.
So may I pray that let it be listed on Thursday.
No, not this Thursday.
Then next week, anytime next week.
29th.
May I please, Your Lordship?
Oh.
Your Lordship, this matter may be listed for orders. Matter relates to challenging the illegal body of some swing association.
4th March.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention on WBC for listing.
Hmm.
Tomorrow, Lordship.
Huh?
Tomorrow
For what?
for listing.
What is the urgency involved for tomorrow?
Lordship, I am an employee of Lokpur PPHC, but without any reason, valid reason, my post has been barred.
Hmm?
I was barred from all kind of duties, Lord,
Hmm.
without any valid reason.
Okay, 28th March.
28.
Yeah.
May it please your lordship.
February. 28th. Yes.
May it please your lordship. I beg to mention item number 24 from today's list, my lord.
Hmm.
The file has been taken away from us, my lord.
Hmm.
So our name may be struck down from the list, my lord.
You are the petitioner?
Yes, my lord. I am appearing on behalf of Mr. B. Kumar, my lord. My name is not there, my lord.
Hmm. Your name is not there, then how can I struck out the names?
Yes, I am appearing on behalf of Mr. B. Kumar, my lord.
Okay. Then I'll list it after some time
Okay, my lord.
on request made on behalf of B. Kumar and the counsel for the petitioner. After 3 weeks?
Okay, my lord.
After 3 weeks.
I am deeply obliged, my lord.
May I please, what do I beg to mention two cases for listing, one for admission and another for order. Lordship, any date, Lordship convenient, any date?
Okay, 6 March.
Like,
May I please your lordship? Lordship, I beg to mention for listing of a matter regarding appointment of disabled persons. Kindly the matter may be come on next week, 27th,
No. 4th March.
4th.
Lordship, I beg to mention for listing this matter for motion, your lordship, on 23rd, your lordship. Actually, your lordship, what happened in this matter, your lordship, petitioner working as accredited engineer, your lordship, he has been terminated, transferred in violation of the notification issued by the commissioner, PNRT, your lordship, and asked to hand over the charge, your lordship. So on Friday, your lordship. Another matter, your lordship, for in item number 17, your lordship.
Yes.
This matter may come on Monday, your lordship.
You're for
I'm for the petitioner, your lordship, K. Mirol,
and request made by K. Malal and council for
on Monday, your lordship,
not Monday. 4th March.
of like.
May I please your lordship? Lordship, there is a matter listed on last year, 3/4/2023, and since then it has not been listed. It is regarding the service matters for the pensioners, your lordship.
Okay, 11th March.
11 March. Your lordship.
May I please, your lord? My lord, I am mentioning a new matter, my lord. The agencies, my lord, we have selection process, my lord,
Of selection process
of my lord, conducted by Women and Child Department, my lord. They are nearby building, my lord. Earlier it was called Women and Child Department. Now it is a Women and Child Department. My lord, the agencies, my lord, the examination is on 25th. And we have been, my lord, very erroneously, my lord, rejected our candidacy. Therefore, my lord, all we have is the my lord till Friday, because Monday examination will be over, my lord. So therefore, my lord, agency.
Okay.
This week accommodate, my lord.
22nd.
That is much of it.
may I please, your lordships?
Yes.
In this case, lordships, after hearing at length and on delivery of the order, my lord and one disputing that petitioners number 1, 2 are not made on compassion appointment. That's why she filed additional affidavit. Today that also may be taken into consideration. Here's the case, lordships. Petition number 1, 2, 3 are engaged on compassionate basis upon the death of their father. The regular
Where's the appointment order?
engagement order, lordships, page 36, report of the authority, lordships. Absolution Mojunda, petition number 1, engaged in watch and ward duty of night chowkidar of the division office against vacant post, right side, lordship, reference and agreement, engaged as honorarium basis by number so and so, dated so and so, on compassionate ground, and pay is being made of daily wages of casual labor. Rates and rates are approved by the SC branch board Silchar. Number 2, Subhash Chandra Rajbangshi, engaged in watch and ward duty at transit camp Silchar at that time. Engaged by letter number so and so on honorarium on compassionate ground. Number 3 is the petitioner Ram Mohan Ravidas, engaged in watch and ward duty at Sunai subdivision office at night against vacant post. Engaged by number so and so honorarium basis, compassionate ground. Right side, their date of engagement, lordship, 2007. And petition number 4, Bulbul Hussain, engaged in watch and ward duty of Tunai subdivision at that time, engaged as per letter number so and so, dated 7/27/28.
So petition number 4 is not on compassionate.
not on compassionate. Petition number 4, fathers donated plot of land for construction Amjurghat. On that basis and requested to make engagement to the petitioners. Accordingly, he was engaged. And they are all were engaged lordship on daily wage fixed pay basis. And since then, they are continuing service. In July 2013, they are all the petitioners attended the office, but they are not provided any duties, subsequently denied. Now, even stated their services have been discontinued. Your lordships is find judgment of your lordships, page 29,
Page?
page 29, lordships,
Page 29.
lordship judgment. Starting relevant person start from page 28, start from judgment, lordships. Relevant prior of the petitioner, lordships mentioned in the first paragraph also. They paid to regularize the services of the petitioner against the existing vacant post of grade 3, grade 4 post. And further direction shall not be issued, resting the respondents for filling our existing grade 3, grade 4 post. Lordship got it. Whole prior question, lordships, here quoted, lordships. Direction as to why the nature of mandamus and the rate of like nature shall not be issued. Command the respondents to regularize the services of the petitioners against the existing vacant post of grade 3, grade 4 of board, and as to why a further direction shall not be issued, restrain the respondents for filling up existing grade 3, grade 4 posts through direct recruitment without considering the cases of the petitioners, and as to why a further direction shall not be issued to the respondents to pay the arrear wages of the petitioners with effect from August 2013 and allow them to continue service, and cause or causes being shown, and upon hearing the parties be pleased to make the rule actually giving full and complete leave to the petitioners. And pass such the father or the order. Then skipping next paragraph, lordships, after next paragraph, then learned counsel for the petition submits that the petition number 1, 2, and 3 are engaged as casual workers on compassionate ground on 1/12/2005, 10/1/2007, and 1/5/2008 respectively. The petition number 4 was engaged as casual worker on 1/7/2007 as he has provided a plot of land measuring about so and so katas of the Brahmaputra board to the Brahmaputra board, Vasishta Guwahati, with a request to provide him a job. Thereafter, in term of the engagement, the petition number 1 was initially paid rupees 1,900 per month, and the other petitioners are paid rupees 2,000 per month. The wages of the petitioners subsequently enhanced to rupees 4,500 per month. The petitioners are paid their wages regularly till the month of July. However, from the month of August 2013, the petitioners have never paid their wages, nor provided any job, despite attending the office of the respondents board regularly. Then skipping lordships, no, regarding honorarium. Next page, lordship will find after 4th line, 5th line. In response, the respondent 5 replied by letter dated 31/12/2013, stating amongst others that due to non-availability of approval from the competent authority, the casual workers could not be engaged since August. On that basis, we are not continued. Then lordship, it is also submitted that respondent board submitted a report dated 4/7/2013 for engagement of contractual labor for various maintenance work under the establishment. However, despite the submission of the report, no steps have been taken by the respondents. Learned counsel for the petitioner submits that engagement the petitioner numbers 1, 2, and 3 were made on compassionate ground, and therefore they have accrued right to get preferential treatment in the matter of employment. It is also submitted that as the petition number 4 has provided land for implementation of Amdur project under respondent board with the understanding that the job would be provided to the petitioner number 4. Therefore, the action of the respondent in not engaging the petitioner board is arbitrary and without fair play. It submits that the petitioners have been serving the board for the past about 7 to 8 years, and therefore they should be appointed on regular basis, and the direction should be issued to release their wages with effect from August 2013. Learned counsel for the petitioner has placed strong reliance on the report dated 4/7/2013 and submits that the report would clearly indicate that there are regular vacancies in the establishment of the respondent board, and therefore there are no reasons why the respondent cannot appoint the petitioners on regular basis. The learned counsel for the petitioners has also placed reliance in the case of Vedavati Das, the Director General, All India Radio and others reported 2008 to GLT 265. Ms. R. Devi, learned CGA appearing on behalf of the respondents, on the other hand, submits that the engagement of the petitioners are made purely on honorarium basis, and initially they were engaged in Harang Drainage Development Scheme and later in the Amtur Drainage Development Scheme. The Harang Drainage Development Scheme was completed in March 2011 and handed over to the state government, whereas the works of Amtur Development Scheme was stopped after completion of embankment portion of work in 2013. After July 2013, the petitioners could not be engaged under Brahmaputra Valley Division inasmuch as the board has no estimate for payment of honorarium on engagement. Learned CGSC also submits that the claim of National Court that he has provided land for the Amju scheme with the understanding that he would be provided a job is not correct, inasmuch as it was the district authority, Kachar, who had acquired the land for the scheme on payment on due compensation. Therefore, the question of giving a job to the petitioner does not arise under any circumstances. It is also submitted that as per policy of the central government with regard to appointment on compassionate ground, a maximum of 5% total vacancies is provided by calculating on the basis of direct recruitment vacancy for Group C and D posts, including technical posts that has arisen in the year. The said policy is strictly followed by chronologically preparing the list of candidates for compassionate grounds. She submits that the name of petitioner numbers 1, 2, and 3 appeared at serial numbers 3, 37, and 43 respectively of the prepared list for compassionate appointment. However, as the Government of India policy further provides that the name of any aspirants for compassionate ground cannot be kept in the list for a period exceeding 3 years, and therefore the claim of petitioners for compassionate appointment cannot be entertained as 3 years has already elapsed. She further submits that the case of the petitioner court do not come within the purview for consideration under the said compassionate appointment policy. In the facts and circumstances of the case, she prays for dismissal of the writ petition. I have considered the submissions forwarded by the learned counsel for the parties. The affidavit in opposition filed by respondents and clearly indicate that petitioners were all engaged on honorary basis initially. Against the Harang Drainage Development Scheme and thereafter to the Amjud Drainage Development Scheme. The first scheme was completed in March 2011. The later scheme was completed in 2013. No affidavit reply has been filed by the petitioners rebuting the claim of the respondents. Therefore, in the facts and circumstances of the case, it is construed that the petitioners engaged on honorarium basis to a particular scheme, and their engagement ends with the completion of such scheme. The letter dated 31/12/2013 written by the respondent board to the writ petition would also indicate that petitioners could not be engaged from August 2013 due to non-availability of approval from the competent authority. The contention of the learned counsel for the petitioners that there are regular vacancies under the respondent board as per report dated 4/7/2013 has also been considered. However, a perusal of the reports does not indicate the existence of regular vacancies being available with the respondents board. In that view of the matter, this court is unable to give a direction to the respondents for further engagement of the petitioners on honorarium basis or otherwise. It is also an admitted position that the petitioners are not engaged beyond July 2013. Therefore, no directions can also be issued for release of their wages from August 2013 onwards. Reliance placed by the learned counsel for the petitioners in the case of Vedaviti Das Supra has also been considered by this court.
Yes,
That's-
I've read.
Yes, lordships, here affidavit they have filed, that's I have annexed two stands taken, one regarding engagement against the post, and the stand taken against the drainage. So there are the two contradictory. And your document says we have been engaged against the post, not against the scheme. They have provided our fixed salary against the scheme. That is their duty to provide that since we discharge the duty, we are entitled to get. Where from that is their, they have to know the slip, their duty. We are not concerned about. Affidavit lordship, I have also annexed lordship page 22 of the revision petition.
No, but where's the error apparent on the face
Error,
of it?
yes, lordship. This is error. Only lordship considered regarding scheme is already been over. That is not actually correct. Page 36, lordship. We have been engaged.
Page?
Page 36. Not against the scheme, lordship. There's an error. That is data 4/7/2013. Issued, it is issued by the authority, lordship.
Hmm.
Second column, lordship, page 36. Engaged in watch and ward duty of night Sukidar of the division office against vacant post. Number 2, engaged in watch and ward duty at transit camp. Engaged, number 3, engaged in watch and ward duty at Sunai subdivision office at night against vacant post. Lordship, you find 1 and 3 find against vacant post. Others are no vacant post but engage against the post. There is
But then you are appointed on, you were engaged on honorarium basis
honorarium, yes, honorarium means
against a particular scheme.
scheme.
The
No.
scheme is over.
Yes, not engaged against scheme. As per records shows that we are not against the scheme. It is also 2013 against the post. They have their affidavit also says also. That's I have annexed. Next page also, lordship, that is 2014, page 37, and the document. Third column, lordship, file. All the 4 petitions are serially 1, 2, 3, 4. Third column, reply in observation number 2. Engaged in watch and ward duty. Night Sukidar at division office Silchar against vacant post. Number 2, engaged in watch and ward duty at transit camp Silchar at daytime. Engaged in watch and ward duty at Sunai subdivision office at night against vacant post. Engaged in watch and ward duty Sunai division office at daytime. So that is not correct actually submission of the other side, lordship, that against the scheme. Their own document shows we have been discharge duties against the post, even against the vacancy also.
Devi, is this engagement against the
Yet,
scheme?
No, Lord, yes, Lordship. It is against drainage development scheme, Harang drainage development.
Where do you get that?
Lordship, I can see.
their affidavit, one
affidavit
paragraph.
is-
first.
I'll just.
Filed in our review petition, Lordship.
Hmm?
In our affidavit filed in the review petition. Annexure 1, page 9. It is Afzal Hussain Majumdar, Lordship, and this is SDDS, means Lordship Singla Drainage Development Scheme.
1 minute. Where?
In our affidavit, Lordship, page 9, annexure 1. In the review petition affidavit, Lordship.
Hmm.
running page 46.
46.
Okay. Yeah,
This is
proceed.
Afzal Hussain Majumdar.
Okay, I'll hear you.
Yes, Lord.
Lordships, my learned friend says against scheme that is not, I did not find here. As per the approval of the committee headed by, may I read Lordships, that page 46 running page, their affidavit.
Mm.
As per the approval of the committee headed by the superintending engineer Silchar Circle, Brahmaputra Board, Silchar, the enhancement of wages of the following temporary casual workers is hereby accorded sanction as per details shown below. Name of the incumbent, first absolution is the petition number 1, office so and so, enhanced rate shown, date of effect shown, then sub work contingencies that not find against the scheme.
STDS.
SDDS,
Singular
C1
Drainage Development
contingency.
Scheme.
There are other documents against post.
Lord,
Is
sir,
not
their
my document.
honorarium
Wait.
serves from this Lordship Drainage Development
Wait.
Scheme. And as per the requirements of work, they were engaged where the exigencies arise, Lordship. So it is not a permanent appointment or against any vacancy. Their appointments were not appointment, it is engagement of
My landed page will take
against
chance, Lordship.
agencies.
I am Lordships. Then they are engaged. Their affidavit, Lordships, against the review petition running page 40, Lordships. Kindly see page 40. They are in the review petition affidavit. In internal page 3, running page 40.
Yes.
Lordship got it. Number 1, absolution Majumdar, date of engagement 1/12/2005. Last date of engagement July 2013. Remarks: engaged on honorarium basis in watch and ward duty as night chowkidar at
Yes.
division office Silchar.
Yeah.
Number 2, Subhash Rajbangshi, engaged 10/1/2007. Last engagement July 2013. Engaged on honorarium basis in watch and ward duty at transit camp Silchar during daytime. Rammohan Ravidas, he is the petition also, 4th petition also. Engaged on honorarium basis in watch and ward duty at Sunai subdivision office Silchar during night time. Engaged on honorarium basis in watch and ward duty as per requirement of site ward. Only number 4 in respect of petition 4 says requirement of site ward. Number 1, 2, 3 stated against the post. Even that time there is no whisper that we have been engaged against the scheme. In the review petition affidavit, even in the affidavit filed in the writ petition, that's also reflected. One paragraph that states we have been engaged against the scheme. That's why there's an error apparently at the face of records, Lordship. And regarding I placed vacancies, Lordships, the writ petitions, that's documents also and
Mm.
Lordship.
Yes.
In regards to vacancies, Lordship, page 21 of the review petition. Page 21. That was also my submissions regarding vacancies are there. They may be observed against that vacancy.
Yes.
Page 21. The report was prepared in the year August to Lordship, first top of the line, Lordship, estimate for engagement of contractual labor for various maintenance works under Borakbeli Division, Brahmaputra Board, Silchar for the period with effect from August 13 to March 2014. May I read the report, Lordship? This estimate amounting to rupees so and so only has been framed to show the probable expenditure to be incurred in temporary engagement of contractual labor against vacant post of chowkidar, etc. under Borakbeli Division Brahmaputra Board, Silchar, for the period with effect from August 2013 to March 2014, that is 8 months. Details of engagement along with reference for instruction for engagement of these persons on compassion ground are shown in Annexure 1 and 2. Just already we read about page number 36, 37, their engagement shown. That is the reflection. Five numbers of persons who had been engaged in different works under the Barak division since 2006 as per instruction of the higher authorities of Brahmaputra Board on compassionate ground, and one person engaged to help in tracing, drawing works, etc. with effect on 1/7/2006 against vacant post of tracer by the then Executive Engineer Barak Division, Silchar, in tracing works and intimated to the CEINW by this letter dated 21/7/2006, copy enclosed and Annexure 3. Moreover, there is no regular tracer in this division office. Once PwC SA was engaged for tracing drawing since long back, but he will be superintended in the month of October 2013. Hence, engagement of a tracer is also required in this division. So one post here is find as a vacancy. Next paragraph. In this connection, it may mention here that there is no chowkidar in both the subdivisional office at Sunai and Manipur subdivision. There is no regular chowkidar in division office, Silchar also. In absence of regular chowkidar, the contractual laborers are engaged for watch and ward duty for the officers at night, etc. Here is the petitioner's case, Lordship taking. There is also 3 posts of chowkidar. One is in the tracer post, Lordship. That's Annexure 1 and 2 reflected in paragraph 36, Lordship, of my review petition. So there are also vacancies. In respect of my learned friend says, the 3 years have been elapsed. In the review petitions, they have annexed the documents level that has been withdrawn. The review petitions, they have stated running page 43, Lordship. Paragraph number 12 of the affidavit of the board, Lordship. Lordship got it. Running page 43, internal page 6, paragraph 12. May I read, Lordship?
Yes.
That with regard to statements made in paragraph 9, the deponent begs to state that at present there is no vacant post in Brahmaputra Board to engage on compassionate ground. The petition number 1 to 3 have already applied for engagement on compassionate ground as per the central government rule, up to a maximum of 5% of total vacancies calculated on the basis of direct recruitment vacancies for Group C and D post, including technical posts that has arisen in the year. This rule is strictly followed while chronologically preparing the list of candidates for compassionate appointment. Since the names of the petition number 1 to 3 are included in the list, they may once again apply for appointment on compassionate ground. The provisions, instructions contained in OM dated 5/5/2003 regarding time limit for compassionate appointment stands withdrawn in view of the Honorable Court of Allahabad judgment dated 7/5/2010, and the case of compassionate appointment are to be regulated in terms of instructions issued by OM dated 9/10/1988 as amended from time to time, OM dated 26/7/2012, order number 10 of section 6, but that the petitioner code is not an eligible aspirant for compassionate appointment and his name is not enlisted as aspirant for compassionate appointment. That document that annexed, Lordship, that is at page 50, running page, internal page 13. relevant portion, Lordship will find page 52 bottom, clause 9 sub clause 3, 52 page, running page. Time limit for making compensation appointment. The provisions instruction contained in OIM dated 5/5/20 regarding time limit for compensation appointment stands withdrawn in view of the Honorable High Court of Allahabad judgment dated 7/5/2010. And the case of compensation appointment are to be regulated in terms of instruction issued by number so dated 9/10/98 as amended.
Where is this OM 1998?
Lordship, it is annexed in our additional affidavit.
Additional affidavit that annexed receipts.
At page 66.
Lecture?
Two messages in our additional affidavit.
67. Inner page 67.
Here. Page number is.
Yes.
But my learned friend also disputing the petition number 1, 2, 3 are not appointed on a compensation appointment. Here is my I'm placing the document says we are engaged on compensation appointment and that there is a relaxation even if there is no vacant post, they may be engaged temporarily for livelihood of the family. Page 68, Lordships object scheme for compensation appointment number 1 clause object. The object of the scheme is to grant appointment of compassionate grounds to a dependent family members of a government servant dying in harness or who is retired on medical grounds, thereby leaving his family in penury and without any means of livelihood. To relieve the family of the government servant concerned from financial destitution and to help it get over the emergency. My learned friend disputing since they were engaged without any post. So it is not on compensation appointment. So I am placing Lordships page 671. Clause 7, subclause C. Lordship got it? C. While the ceiling of 5% for making compensation appointment against regular vacancies should not be circumvented by making appointment of dependent family member of government servant on casual daily wages ad hoc contract basis against regular vacancies, there is no bar to considering him for each appointment if he is eligible as per the normal rules orders governing such appointment. Since we have been engaged on casual basis, fixed where they have been paid. So there is no bar also for considering. Here upon in the Lordship will find in my review petition on not additional affidavit, affidavit, general affidavit of the respondent's Lordship, page 4, page 41 of their affidavit. Paragraph 7. That with regard to statements made in paragraph number 4, the deponent begs to state that due to lack of approved estimate, the budget for payment, the engagement of December petitioners from 1 to 4 was discontinued from August 2023. Paragraph 8, that regard to statements made in paragraph number 5, the deponent begs to state that petitioner number 1, 2, and 3 are engaged on honorarium basis by the executive engineer Borakbeli Division, Brahmaputra Board, Silchar, to ease out their livelihood immediately after the death of their fathers, who are the employees of Brahmaputra Board. So as per scheme lordship allowed, there may be any person may be engaged on casually daily to mitigate their penury condition lordship and for livelihood. They also admitted in their affidavit also. And regarding lordships, they also stated our service have been discontinued. That is also arbitrary, with no opportunity has been also been given since the petition 1 to 3 on appointed compensation grant. Lordship, I am placing the reliance already earlier person placed lordship. In respect of review petition lordship, first I am referring
Yes.
lordship 2007 to GLR, that records are available. Decisions are available in the file.
2000.
2007 to GLR
1 minute.
or 2005 for GLP.
2000. Yes.
Krishnamohan Jamatia versus State of Tripura and others. Paragraph number 6 and 7, may I read lorships? FSS Code decisions. Lorships, that paragraph is quoted, FSS Code. Paragraph 6, the FSS Code. The FS Code in Board of Control for Cricket, India versus Netaji Cricket Club, Year 2005, SC 952 has succinctly explained the appropriate provisions in the following words. Paragraph 88, 89, 90, the quoted. Section 114 of the Code empowers a court to review its order if the conditions precedents laid down therein are satisfied. The substantive provisions of law does not prescribe any limitation on the power of the court except those which are expressly provided in section 114 of the Code, in terms whereof it is empowered to make such orders as it thinks fit. Order 47 Rule 1 of the Code provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence, or when there exists an error apparent on the face of record, but also if the same is necessitated on account of some mistake or for any other sufficient reasons. Thus, a mistake on the part of the court, which would include a mistake in the nature of the undertaking, may also call for a review of the order. An application for review would also be maintainable if there exists sufficient reasons. Therefore, what would constitute sufficient reasons would depend on the facts and circumstances of the case. The word sufficient reasons in Order 47 Rule 1 of the Code is wide enough to include a misconception of fact or law by a court or even an advocate. An application for review may be necessitated by way of invoking the doctrine actus curiae nemini gravity. From the foregoing paragraph, it becomes apparent that scope of review need not be confined to discovery of new and important piece of evidence, an error apparent on the face of record.
Yes. I've read.
Yes, lost. Then lorships in respect of compassionate appointment lordship, case of 2008 to GLT 265.
Mm.
Vedaviti Das petitioners. That also in the earlier question I relied Lordship judgment.
I have,
Now I'm relying paragraph number. Lordship got it?
yes,
Paragraph number 1. Exactly same, similar facts. Lordship. May I read paragraph 1? The petitioner who was appointed as typist on monthly contract basis on compassionate ground under the respondent of 5 is agreed by dispensation of her service. Be it stated here that there is no written order towards dispensation of her service. Paragraph number 2. Sorry, Lord. The father of the petitioner, while was serving as driver in the office of the respondent of 5, died on so-and-so. Considering the plight of the family, the petitioner, his daughter was appointed as aforesaid by Annexure 1, order dated so-and-so. It was indicated in the order that her such appointment was on compassionate ground till such time a clear decision was received from the higher authority against the vacant post of LDC of Agartala subdivision. Then I read paragraph number 4, Lordships. The writ petition was filed on 6/10/2004, and as per the statements made in paragraph 7 of the writ petition, she was still continuing in her service, being engaged in various jobs. According to the petitioner, she having continued in the service for long 8 years, by now 11 years, she is entitled to get regulation of the service or at least temporary status in terms of the scheme for grant of temporary status and regulation of casual workers formulated by the Government of India in the Department of Personnel and Training and circulated by OM dated 10/9/1993, effective from 1/9/93. Then paragraph 8. In paragraphs 12 and 15 of the written statement, the respondent stated that the petitioner was engaged on casual basis to give her instant relief after her father's death on humanitarian ground. It was also stated that her case would be considered at the appropriate time by competent authority. Then, Lordship, paragraph number 19, may I read, Lordship?
Mm.
In paragraph 6 of the main affidavit, the respondents have stated that the writ petitioner is paid as per financial sanction against wages based workers of the department. Exactly similar case. Lordship. Then paragraph 20. From the above materials, there is no manner of doubt that the petitioner in whatever form was in the employment of the respondent till filing of the writ petition on 6/10/2004. It is in reference to this, her plea regarding dispensation of service with effect from 14/10/2004 by the respondent 7, which fact has been brought on records by bringing amendment to the writ petition, will have to be considered. The simple plea of the respondents is that since the petitioner was not in service on 14/10/2004, there was no question of misbehaving with her. That is not required in the facts of the 10th paragraph 24. The petitioner was appointed admittedly on compassionate ground. In the order of appointment, apart from mentioning the same to be on contract basis, no duration of the same was indicated. By Annexure 5 letter dated 3/12/97, the respondent of 5 intimated the authority about 2 vacancies of LDC, one lying at Silchar and another at Agartala, against the quota earmarked for compassionate appointment. The petitioner is appointed by order dated 25/3/1996 on contract basis till a clear decision was received from the higher authority against the particular vacant post. There is nothing to indicate that the case of the petitioner was considered against that particular vacancy or against the vacancy at Silchar. Then paragraph 28. The petitioner was appointed on compulsory ground. There is no dispute that at that relevant point of time, there were 2 vacancies of LDC. The respondent applied by his annexers 5 letter dated also intimated the authority about the state position with request to accord necessary approval for appointment the petitioner against the quota earmarked for compulsory appointment. In the proceedings before the tribunal, the respondents denied the appointment the petitioner on compassionate ground, unmindful of the fact that the very order of appointment of the petitioner indicated ground of appointment as compassionate. In the written statement filed before the tribunal, the respondent stated that the case of the petitioner had been recommended to the competent authority for appointment on compassion ground as LDC. It was also stated that she was engaged on contractual casual basis to provide instant relief in view of death of her father. It was further stated that her case would be considered at the appropriate time by the competent authority. Then paragraph 34. The purpose of providing appointment on compassionate ground is to mitigate the hardship due to death of the breadwinner in the family. Such appointments should therefore be provided immediately to redeem the family in distress. In fact, the petitioner was provided with compassionate appointment, and perhaps she would have continued in her service, but for the incident on 14/10/2004, the object to provide compassionate appointment is to give succor to the family which has been suddenly plunged into penury due to the untimely death of its sole breadwinner. While it is true that there cannot be endless compassion, as has been contended by the respondents, but the instant case is not of that nature. The petitioner was provided with compassionate appointment, maybe on contractual basis, in the monthly salary of rupees 950 plus DA. Her such appointment was also not for any limited duration. There was change in pay structure. The first affidavit filed by the respondents, it has been admitted that the petitioner continued in a service for 8 years. However, in the additional affidavit, altogether, a different stand has been taken, stating that the petitioner was not in service after 31/3/2000. Thus, the petitioner having been provided with compassionate appointment at the appropriate time, such appointment ought to have been continued with consideration for regulation of the same. Paragraph 36, then on the materials, 36, 37, 39, yes. Exactly similar rest of case, Vedavati Lordship, 1, 2, 3. Now they denied, we are, 1, 2, 3 have not been appointed compassionate. Their own documents, we have been engaged on compassionate ground upon the death of our father. And suddenly they stop our engagement. That is totally arbitrary decision. And even now stating that our service could discontinue, that is also no opportunity, nothing else. In respect of petition for full lordship, maybe a casual temporary employee, but some opportunity may be provided. In this regard, I am placing reliance of this all court lordships. And the Supreme Court also lordship. AIR 2003 SCC 239 BP Ahuja versus State of 2003 SCC 299 first line lordship AIR 2000 Supreme Court 1080. Parties are BP Ahuja versus State of Punjab and other. BP Ahuja.
Yeah.
AIR lordship.
That is not here.
Those SCC others are also reflected sir.
SCC is which one?
As 2003 SCC 239 BP Ahuja lordship.
Oh, yes.
BP Ahuja
Mm.
versus State of Punjab, paragraph 7 and 8.
Yes.
A probationer, like a temporary servant, is also entitled to certain protection, and the service cannot be terminated arbitrarily, nor can those services be terminated in a punitive manner without complying with the principles of natural justice. At least to issue to notice lordship our service. After filing of this writ petition, they now state our service of this. There is not sustainable law. And our High Court also lordships 1998 1 GLT 326 Union of India and others versus Mohendra Chaudhary. Lordship got it.
Yes.
This is division based judgment. Para 9 and 11.
Which is it? What is the
Paragraph 9
reference?
after paragraph 9 lordship third
19?
paragraph 9
No, no, no.
Lordship, citation 1998 1 GLT 326
Yes.
Union of India and others versus Mohendra Chaudhary.
Hello?
Paragraph 9 lordship.
Mm.
Lordship, be that as it may, lordship got it.
Mm.
Be that as it may,
No, no,
it
no.
appears that
1 minute. Mahindra Chaudhary.
yes, lordship, Mohendra Chaudhary.
Hello?
Para 9 third paragraph 9 subpara 3.
Hmm?
Be that as it may. After 1, 2, after 13, 14 line lordship.
Oh,
Line.
para 9.
Para 9.
Mm.
Be there as it may. It appears that the service the petitioner was terminated in a most arbitrarily capricious and whimsical manner. A person cannot be thrown out from the service according to pleasure of the authority. It must be done for some reasons, and these reasons must be communicated, made known to a person, as the authority is taking away the livelihood of the petitioner. And that was not done in the instant case. Exactly similar text, my case. Then paragraph 11, only first sentence I am reading. It is a declared concept of law that once a citizen has been offered a post and the citizen is working by virtue of an order of appointment, the provisions Article 311
This is not
is against post lawsuit actually, but since we have not been against the post but against the temporary casual, not sanctioned our post, discharge against the post, casual employment. And another thing disputing only honorarium. Honorarium means lordship is a salary. It's not an appointment. Honorary may be a temporary, casual, permanent, master role, like that. So my learned friend says, already realized that it's an honorary appointment. Honorary may be salary, cannot be honorary appointment. May relying upon the decision of the Honorable Appeals Court Lordship, 1975, 1 SCC 252 regarding honorarium.
Yes.
Harbari, Bhimaji, Rohamari versus Shankar Lordship.
Yes.
Paragraph 6. The whole controversy centers around the honorarium payable to the members of the wage board. It is contended on behalf of the appellant that item 11 specifically lays down that the compensatory allowance shall mean traveling allowance, the daily allowance, or such other allowance which is paid to the holder of the office for the purpose of meeting the personnel expenditure is attend the meeting of the committee or body, or in performing any other function as the holder of the said office. An honorarium which is not mentioned that cannot be brought within the meaning of the word. Such other allowance found in that item as it is not an allowance. Reference is made to the dictionary meaning of the word honorarium, and it is said that while the daily allowance is expected to meet the expenses of a member concerned while attending the meeting of the board, the honorarium is in the form of a fee for performing his duties on those days. The Shorter Oxford Dictionary gives the meaning of the word honorarium as an honorary reward, a fee for professional service rendered, while one of the meaning of the word salary is fixed payment made periodically to a person as compensation for regular work. Remuneration for service rendered, fee honorarium. So here is the case, Lordship, the fee provided, fixed payment, we got lost in the documents.
Yes.
Yes, this case, Lordship, deserves consideration, Lordship, 1, 2, 3, and 4, even other schemes are available, may be considered. But 1, 2, 3, the deserves continuation and subsequent regulation on the basis of Vedavati's case. Lordship. And 4 schemes, since schemes are available, Lordship, new schemes have started, his case may be considered. It may not be compulsion permanent, but as since he provided land or with the understanding a job may be provided, accordingly they provided
That land was provided for a particular scheme.
scheme, Lordship, scheme
Is
is
it
over.
one
Yes,
more,
yes.
more,
After
Yes.
drainage development. Also, it was
Scheme work is over, Lordship. That's
that
why
scheme was abandoned,
yes,
correct?
yes.
And the other ground is that the district administration procured the land.
Yes.
yes,
Yes.
by
there was
giving due compensation lots of.
There was no agreement between the
Yes, Lord.
respondent and you.
Verbal
Oh.
understanding, but there is no written agreement, a permanent job, but verbal understanding, that's why they have immediately provided job also. He may
Yes.
be continued, Lordship. There is a this service may be continued. Both has sufficient vacancies also, they are taking person on casual basis, temporary basis. This case may also be considered since for livelihood, Lordship, she immediately engaged, they have provided, suddenly stopped his engagement.
Yes.
This is my
Lordship,
humble submission.
this is a review petition, Lordship, and under guard of review petition is trying to rehear the matter like an appeal or petition. Lordship, all these facts with the he has stated, Lordship, all these facts were brought on record by filing an affidavit in the petition, and he has not reviewed it in the by filing any affidavit in reply, and this fact was also mentioned by your Lordship in the order itself. Now, same facts there he is trying to Lordship brought on record. And secondly, Lordship, they were appointed on honorarium basis against Lordship drainage development scheme, Amtur drainage development scheme, and Singla drainage development scheme. And after completion of the scheme,
What scheme? Singla.
Singla. Respondent number, petitioner number 1 in
Where is that scheme? Where is that scheme?
scheme Lordship
Where have you mentioned?
mentioned Lordship space 46 of our
Page?
affidavit.
46.
Lordship. And it is also stated in our in paragraph Lordship 8 of our affidavit.
Where?
Also annexure 1,
No, that where.
the statement Lordship.
Where have you mentioned in para 8?
8 Lordship, last para. The applicants engagement, the applicants were engaged till July 2013 as per the requirements work under which their payment were charged. Initially, they were engaged in Harang Drainage Development Scheme and then in Amtur Drainage Development Scheme. The first scheme has already been completed in March 2011 and handed over to the state government, whereas the work of Amtur Drainage Development Scheme has stopped after completion of embankment portion of the work in 2013. The estimate of balance works, including the sluice, is yet to be approved by the competent authority and to be sanctioned by the government of India. After July 2013, the petitioners could not be engaged under the Barak Valley division as the board has no approved estimate and budget for payment of honorarium on engagement. Under the circumstances, further engagement of the petitioners on honorarium basis is not possible.
Para 11.
And then let's say paragraph 11. Paragraph 11, let's say, married. That with regard to the statement made in paragraph 8, the deponent begs to state that the petitioners were engaged in honorarium basis on working arrangement, but their payments were made against various drainage development schemes, such as payment of petitioner number 1 was charged in Singla Drainage Development Scheme. Payment of petitioner number 2 was charged in Singla Drainage Development Scheme. Petitioner number 3 was charged in Amtur Drainage Development Scheme, and petitioner number 4 was charged in Harang Drainage Development Scheme. The petitioners were not engaged against any vacant post.
That is not correct.
Also, this is not it is not their engagement not against any vacant post.
That
As
is
per
not,
the
that is not
requirement-
correct. That is not correct.
As per the requirements of work, lordship, they were engaged against vacant post
You
or any other
come to the writ petition.
site works, lordship.
Page 36.
Lordship.
Not the
Review petition.
review petition. Page 36. Column 2, petitioner number 1 against vacant post. Petitioner number 3 against vacant post.
Let's say, not vacant, they were, let's say, as per the requirements of the work, let's say,
But
they
this
were
is,
engaged.
it is
lordship.
against
It is
vacant
not
post.
a regular appointment against any vacant post. The posts were lying vacant, and as per the requirement of the work, they were engaged against this post for during the period of their engagement.
How do you explain that?
And also, since India, in our affidavit, we have stated that there was no vacant, their appointment, and for appointment against vacant post lawsuit, they have to go through a regular recruitment process. No such regular recruitment process was initiated. They were simply engaged for some, let's say, as per the requirements of the work, they were engaged, and their honorarium were charged against the drainage development schemes. As soon as these schemes were completed, their engagements were also terminated. And in the repetition also, their prayer was to regularize their services against their engagement against posts lying vacant. Now in the review petition, they're arguing that they were appointed against vacant posts. Now they have improved their case that they were appointed against vacant posts, and in their repetition, their prayer only one prayer that they were to be appointed against post lying vacant, they get for post and area wages be paid. And secondly, lordship, regarding compulsory appointment, lordship, it is stated that they can apply. There was earlier it was a part that 3 years.
Can they still apply now?
Yes, lordship, as per our affidavit, they can apply for compulsory appointment provided they fulfill the lordship, provisions of the scheme of 1998.
Where's the scheme?
Yeah, in our additional affidavit, lordship. In your additional affidavit, annexure 2. And
Where's
for
the-
compassionate appointment,
where's the
Lordship.
additional affidavit?
Okay.
Where's your additional affidavit?
Page 67, Lordship.
Page 67. Hmm.
Page 67, and the requirement for such compassionate appointment is at page 69, Lordship. Page 69. Clause 3, Lordship. First, it is the authority who can appoint, who can make appointment on compassionate ground, Lordship. This is Joint Secretary in charge of administration in the ministry. Second, head of the department under supplementary rule, and secretary of the ministry department concerned. Here, the petitioner's appointment to an engagement were not made by any of these authorities. First,
But does the Brahmaputra
none of the board, Lordship.
board
Board.
comes under this compassionate appointment?
Yes, Lordship. The Brahmaputra board is a central government organization. So this scheme is applicable to the Brahmaputra board under Department Ministry of Jal Shakti.
Okay.
And secondly, Lordship, clause 4. The post to which such appointments can be made. Group C or Group D post against the direct recruitment quota.
Minutes. Close
4, Lordship. Next one.
page.
Page, same page, Lordship, 69.
Hmm.
Group C or Group D post against the direct recruitment quota. Then Lordship 5, eligibility. The family is indigent and deserves immediate assistance for relief from financial destitution. And second, applicant for compassionate appointment should be eligible and suitable for the post in all respects under the provisions of the relevant recruitment rules. And Lordship 6, exemptions. Compassionate appointments are exempted from observance of the following requirements: recruitment procedure. These are, Lordship. Then relaxation, Lordship. Upper age limit would be relaxed wherever.
I've seen.
Lordship.
I've seen.
Yes, Lordship, in order to be appointed.
So your ground is that they were appointed against particular scheme, and
Scheme.
since the scheme is no more there,
Yes, Lordship. And their appointments were not on compassionate appointment, but out of compassion, since the respondent number, sorry, petitioners number 1, 2, 3, father died, who were employees of the Brahmaputra board, Lordship. They out of compassion, they were engaged against the schemes, Lordship. And with the completion of the schemes, since father, there was no budget provision, Lordship, in this respect to continue the scheme, their engagements were discontinued.
okay.
And otherwise also there is no error apparent on this Lordship to file this review petition. Because all these facts were brought on records in the petition and they have not refused it. And now they are trying to improve their case, Lordship, and
Yes.
hearing the matter at the. Oh, Lordship.
Heard yeah, Barbara, and then the counsel for the petitioner also heard MS, heard David, and the.
Everybody.
You're the CGC,
Lordship.
then it's the CGC, I pray on behalf of all respondents.
All the respondents. All the respondents.
Hearing concluded, that's what it is.
Lordship.
Then it will end.
Item 2 and 3 for motion.
Lordship, may please. In this matter, learned counsel for BTC were directed to obtain instruction, my lord. Whether there is one gradation list for the post of tourism development officer or a separate gradation list for BTC, my lord.
Lordship, I have received the verbal instruction. I have sought for the written instruction. As per the verbal instruction, Lordship, the post held by the petitioner is a single post. So there is no requirement of maintaining any seniority by the BTC. And for her next elevation to the next promotional post is a grade 2 post, and that has to be maintained by the government lordship, and they have already sent the proposal way back in 2019. That's a verbal instruction. Lordship may take it up tomorrow. I will have the written instruction because then it will be convenient for lordship.
Okay, tomorrow,
Can it be day after, my lord?
Friday?
Friday.
Oh, what?
Thursday, Thursday?
Thursday.
My
I
lord?
don't know.
Friday.
I'll be receiving it today.
Friday must be Buyan and council, then the senior council, let's sit down and MS. On the first met by the Chaudhry and it's the council BTC, list the met again on 23rd.
Mandela one.
Item for admission.
May it please the lordship.
What is this?
Timing.
Orders.
Lordship, may the matter be kindly pass over for the time being.
Oh, why?
Lordship, actually, this is not our chamber's case. I was handed over the brief to take some time.
Oh, I don't get you. This is a parted matter.
Yes, your lordship. Lordship, petitioners had finished. Respondent also had finished. The finance department, respondent number 2 wanted to submit something which got adjourned, but we've not received anything from them yet.
Yes.
Lordship,
You are appearing on behalf of?
I'm appearing on behalf of respondent number 4, 5, 6, 8, 9, and 10.
He had completed his arguments.
4?
4, 5, 6, 8, 9, and 10.
Yes. What do you want?
Lordship, may the matter be kindly pass over for the time.
My lord, the conducting council in midst of a hearing in court number 1 in item number 16 to 18. Kindly pass on for a time.
5 and 6.
My senior friend will, my senior friend will start my respondents.
You just recapitulate a little bit.
Yes, I'll do it. Oh, my case, man.
Yes.
Oh, yes. Met with your lordship, man. If I'm.
These are records.
Rules and reports, lordship. I'm just pressing it now.
Yes, please.
The claim of the petitioner is for the claim for the post of assistant registrar under the respondent's man. He appeared in a selection that is for the internal candidates. So by way of promotion, man. And in that manner, he was at the top position of the wait list. 4 posts were advertised, and against that, my lord, from the main list, 4 applicants were picked up and they were appointed, and that wait list remained. Now the wait list was not publicized; it was not circulated by the respondents, where the name of the petitioner had appeared at the top, man. And the the norms is, if any further post arises, any further vacancy arises within that particular year, which is called a vacancy year, within 31st of December, then, my lord, the appointment is made from that wait list, my lord, without further going for any other selection. So that is the norm, my lord. And therefore, my lord, but I didn't know, my lord, that my name was there since it was that waitlist was not publicized. It
For
was
one,
not
for 1 year.
for 1 year. Now, this had happened in the month
The vacancy arose in before the.
in June, my lord.
Oh,
In
no.
June, my lord.
The another vacancy arose.
Yes, my lord, June of the year, that particular year, 2022.
Hmm.
The first selection was in January, my lord, 5/1/22. Then vacancy arose, my lord, in June
5/1.
22. Circular, my lord. I'll take your lordship there again. And then, my lord, subsequently that further vacancy was, my lord, again advertised for internal candidates in December 12/12/22. Since at that point I didn't know, I was not aware that my name is already in the wait list. So therefore I applied again, my lord, for that. And that selection process continued. And in May of 23, man, in the month of May, my lord, I came to learn that my name was already there in the wait list at the top position. So therefore, I immediately represented before the authorities. They refused. On the contrary, they said, "Why have you? How they issued a letter to me saying that how have we come across this confidential information?" Then I came before your lordship. That is the case. Now, what has happened, my lord? When I first filed, my lord, at that point of time, my lord, the private response number 7.
Sir.
Response number 7 was not given appointment, man. Whose promotion was, my lord, approved. So therefore, I filed a subsequent petition challenging the approval and the appointment of the private respondent in the second petition. So that second petition is a comprehensive petition, my lord. And there they have filed their affidavits. But my claim is, your lordship will kindly note, not, my lord, related to, my lord, that second selection, my lord. 12/12/22 circular is not relevant for me, my lord, as I have projected my case. That is on the basis of my selection, my entitlement, on the basis of the selection procedure flowing from that circular dated 5/1/22. So that is my case, man. I have got nothing to do with the second selection. I say that since my name was already there and that vacancy arose in that particular year, within that vacancy year, within the 31st December of 22. So therefore, by, my lord, their own procedure, practice procedure, it should have come to me. That is my case. I'll, my lord, reply to my learned senior.
May it, your lordship. So this is the matter where IIT has got
1 minute.
lordship
You are appealing for respondent?
respondent, lordship, IIT Guwahati, respond number lordship, 2 to 6. In the second date petition, lordship, first one is, lordship will take up item number 6. That is a subsequent date petition with modification made by the petition. So in that, I'm appearing for respondent 2 to 6, lordship. Basically, IIT Guwahati. It's the matter, lordship. In fact, IIT Guwahati administration has nothing to lose and nothing to gain in this petition. Because writ petitioner is also our employee. Respondent number 7 is also our employee. Both are competent persons to our case. What is our interest is that the position of rules should be established. So there will be no bad precedent for the future. That's why I'm fighting. This is the position of law, position of rules. That should be lordship, that should be examined by lordship. I'll place the legal facts as the factual positions. Now, the matter relates to selection and promotions to the post of assistant registrars in IIT Guwahati. These posts are categorized in two categories. One is appointment by direct recruitments. One is selection through promotions of the internal employees. Now, at the relevant time, Lordship, for direct recruitment, the 75% of the available posts were reserved for direct recruitments, and the 25% posts were reserved for promotional posts from the employees, internal employees. Now, Lordship, 4 promotional posts had come into existence in the early part of 2022. Then by advertisement dated or circular advertisement dated 5/1/22, we have called for applications from the internal candidates to be promoted, Lordship. Lordship will kindly see the advertisement is at page 99 of our affidavit, Lordship, counter.
Is there in the writ petition also?
Lordship,
Is there in the writ petition, page 27?
the writ petition, they have not annexed that one probably.
5/1/2022.
Lordship, yes.
It is there. That is annexure 1. Correct.
We have also annexed it also here. Lordship, kindly.
So you want to go to your counter
Yeah,
affidavit?
it is there, Lordship, it's there. At page 27, Lordship, the writ petition. The post of Lordship will see. IIT Guwahati invites online application from the eligible internal candidates for the following posts. Now we are concerned with item number 1, assistant register. 4 vacancies were there. And Lordship, the name of the post and the eligibility criteria. Assistant register, he must be superintendent or senior accounts officer with 5 years experience, etc. APAR marks 60. He must get APR marks 60. Total 100. And interview marks 40. Total 100. Now, Lordship will kindly see the general information that below that. Item number 2, clause 3. 3, Lordship. General information, clause 3. The panel selection /waiting list drawn up by the Departmental Promotion Committee, DPC, as per Government of India norms, would be valid for 1 year. If any post falls vacant within 1 year of the DPC meeting, the same will be filled up using the waiting list as per the category. This will not apply to the fresh sanction of posts made after the advertisement. Candidates should be selected as per the recommendations. Now, these 4 posts were advertised. Selection was held for these 4 posts, and that one select list was prepared and one waiting list was prepared. Both were mandatory for the selection board. Lordship, they were bound to prepare a select list as well as a waiting list. These are there, Lordship. And these are for internal candidates who are most experienced employees, superintendent, senior superintendent, etc. Therefore, Lordship, clause 3 makes it clear that
According to the
Lordship,
general information clause 3,
Lordship,
after the panel is made,
yes,
selection panel is
the
made,
2 panels, one is for selected candidate,
and
one is for waiting list
waiting.
candidate. Lordship.
That waiting list will be in operation for 1 year.
1 year to 1 year. That is as per normal practice for those 4 posts. If any post falls vacant, someone doesn't join. In that case, it will be picked up from the waiting list. That's a normal procedure.
No, no, no. Let us read it again.
Lordship,
Let us read it again.
Lordship.
Clause 3.
The panel within bracket selection /waiting list. Panel, both the panels should be prepared. Drawn up by the Department Promotion Committee as per Government of India norms would be valid for 1 year. The panel which is prepared will be valid for 1 year. If any post falls vacant within 1 year of the DPC meeting, My submission is that if any post falls vacant, it means that 4 posts which were advertised for which selection was made. If any one of the posts falls vacant or someone doesn't join, someone dies, then it will fill up on a waiting list. Not against any new post meeting. The same will be filled up using the waiting list as per category. This will not apply to fresh sanction of posts made after the advertisement. If any post advertised means that advertised that is filed, which is given on 5/1/2022. If any new post comes into existence, sanction is a technical term. Any new post comes into existence, which is not there in the advertisement. This waiting list will not be applicable to that particular post. That is the meaning. Normally, Lordship, that waiting list against a regular post which were advertised or that selection had taken place. If any of the posts are not filled up due to any reason, then the candidate from waiting list is picked up there, filled up. Now the new post comes into existence. In that case, there will be new selection.
What does it mean? This will not apply for fresh sanction of post. Fresh sanction means new creation.
That is the crux of the matter, Lordship. Whether this is what had happened, I'll state now.
Now, this is what is the whole issue.
The whole issue, Lordship, whether this is fresh sanction or this is the same post, same. This post which has come now, whether this is the new post then created, whether it can be treated as a fresh sanction of post or this is the old post. That I'll explain now. I'm going to go for it, Lordship, now. Now, so, Lordship, that selection committee prepared 2 lists. One is for 4 actual selected candidate, one is for waiting list. And this was made known that selection committee will prepare 2 lists only. One is select list, one is waiting list. It was not unknown. The waiting list was prepared, it's a mandatory requirement. Now, Lordship, that petitioner is a senior superintendent of IIT, very senior officers. So it is not, cannot be expected that he would not know that waiting list was prepared. This is there in the advertisement itself that waiting list also will be prepared. As per normal practice, Lordship, we selected candidates, we publish its names. Waiting list is not published website, but anyone is free to inspect the waiting list, know his position.
Then why did you ask that question? How the petitioner came to know about this waiting list?
No, that is a subsequent development. He himself said it. I'll come to that also. I'll reply to that. Now I'm placing my facts, Lordship. Now, Lordship, may kindly turn to our affidavit. Lordship, para 77.
1 minute.
Lordship, that page 77, para Roman 11. Para Roman 11, Lordship. That it is respectfully pointed out that the writ petitioner, Lordship, got it for.
Yes.
Writ petitioner is a senior superintendent of IIT Guwahati, thus a very senior experienced employee in the higher level and not a fresh outside candidate applying for the above post. In fact, the institute administration functions through the superintendents of various offices. As such, he is fully aware about the functioning process of the administration of the institute. The petitioner is also aware about clause 3 of the general information pertaining to the advertisement dated 5/1/22, which mandates the selection committee, that is Departmental Promotion Committee, to prepare a waiting list pertaining to the above selection in addition to the select list. The writ petitioner is also aware that all the above 4 posts of assistant registers against which he applied for have been filled up through 4 successful candidates who applied for along with him. Though the waiting list is normally not published, but it is always open for the inspection for the candidates. Being a senior superintendent of the institute administration and being aware of the fact that the Departmental Promotion Committee is bound to prepare a waiting list along with the select list, it is impossible to presume that he did not inquire about the position of the waiting list In view of the above clear position of the records and facts, the deponent presumes that the statement made by the petitioner that he was not aware that his name was placed at the top position of the waiting list is nothing but a false and misleading statement made with the intention to mislead the Honorable Court. It was already published, the waiting list is prepared. And we have publicized the select list. Waiting list is there, you should come and inquire it. He is an old employer, the senior employer of the institute. It is unexpected that he would not enter the waiting list. It is always open, at least you should have, there is nothing to show that he applied for it. He never made any attempt on record to know the position of the waiting list. Surprisingly, he said after 1 year, he appeared second interview. Oh, I did not know, I have just come to know. Why did you not apply then waiting list? Why did you not try to find out? Because that was in the advertisement itself. That selection, both will be prepared by the selecting board. Now, Lordship, so he has not come with clean hands. Having come to know that he knew it. Because he knew the position of the waiting list, he knew it only went for those 4 posts. But that's why he applied for the second post. And now subsequent developments we can see. He never made any attempt, as I said, Lordship, to know the position of the waiting list, though he knew that it was prepared. And he's not an outside press candidate, he's from inside, senior employee of IIT. Now, Lordship, can you see that now, Lordship, as per normal rule, the service rules, recruitment rules are subject to different sort of revisions from time to time. A body was constituted by IT authority, our experts, to revise the waiting list or to revise the service, the recruitment rules. And this body, Lordship, committee submitted its recommendation. Lordship, you kindly see that in annexer in para 3, 70 page 74 of my affidavit. Page Roman 6, Lordship. As per some administrative requirement, the institute authority had constituted an expert committee for reviewing the existing recruitment rules made for the non-teaching employees of the institute. The said committee, on conclusion of their examination, had made certain recommendations. One of the recommendations was to earmark 50% of the post of assistant register, along with a revised eligibility criteria and revised assessment matrix, to be filled up by the promotional recruitment, whereas earlier only 25% of the said posts were filled up by promotion and rest 75% were filled up by direct recruitment. This recommendation of the said committee was placed before the 111 meeting of the BOG held on 17/6/2022 for its approval against the agenda item number 20. The said BOG, by its resolution by number such, had approved the recommendation of the committee. As a result thereof, 50% of the available post of assistant register in the institute stood earmarked to be appointed by promotional recruitment after 17/6/2022. That is the date on which BOG approved the recommendations of the committee. That's very good. Due to the fresh sanction of additional 25% of the promotional recruitment of the assistant registrar's post from 25% to 50%, one new post of assistant registrar came into existence on 17/6/2022. That is the date of approval of BOG, which earlier remained in the direct recruitment quota. This is recently come. That there are 2 types of posts. One is direct recruitment post, one is the promotional post. This post was not there till yesterday. It has come only after this recommendation is accepted by BOG, and new post has come as promotional post. And for this post, next, the IIT being an autonomous institute having its own statutes, it does not strictly use the terminologies as used in other central government departments. By mentioning this will not apply for fresh sanction of posts made after the advertisement in clause 3 of the general information. It simply meant that the above waiting list cannot be used to fill up any promotional post of assistant register, which comes into existence after the advertisement dated 5/1/2022. On the date of this advertisement, 5/1/22, this post was not existing for promotional candidates. It has come because of this recommendation and acceptance of the BOG on 17/6/22. Now, let's see that next para I read. The promotional post of assistant register, which was advertised to advertisement dated 12/12/22, did not exist at the time when the advertisement dated 5/1/22 was issued for filling up 4 number of distinct promotional posts of assistant register. And therefore, petitioners claim to be appointed to this post advertised on 12/12/22 on the basis of the waiting list prepared on 18/2/22 with regard to the selection of candidates for the above 4 posts is totally baseless. I read further, next paragraph. In addition to above, the eligibility criteria and assessment matrix for this freshly sanctioned post, which is sanctioned because we strictly do not follow the terminology which in other secondary departments, which is sanctioned with new post which has come into existence. It's not that officially post which is sanctioned, which mean, because these are our terms, Lord. All eligibility criteria, where it is 4 posts are advertised. Senior superintendent of senior accounts officer with 5 years of experience or superintendent of such and such. Now revise for this post, new qualifications required. Revise eligibility criteria. Senior superintendent, senior accounts officer, Hindi teacher, higher pay level with minimum 5 years experience in pay level 8 and above. This was not there in earlier. This qualification was not there in earlier advertisement. Now, assessment matrix, Lordship. Annual performance appraisal report, old one, APAR, marks for last 5 years, actual 60%. Performance in the written test interview, 40%. That was that, Lordship, that the assessment matrix required. You have to get 60% in annual performance APAR and written test or an interview 40%. Now revise, Lordship, assessment matrix for this new post is that annual performance appraisal report marks for last 5 years at actual 50%. It was 60% earlier, 50%. Performance at written test interview, 45%. Length of service in the present post in the institute, 5%. Formula for calculating the marks corresponding to 5%. Weightage for the length of service at the institute is as follows. New qualification, new mathematics is required here, Lordship. Therefore, Lordship, next page, I read the Lordship.
After 5 minutes.
Lordship. Lordship, here the committees submitted a recommendation for 50%, 50% of the year, and it was placed before the board. Now, board has, Lordship, this is the proceeding of the board. I'm only relevant part I'll point out to a lot. Board was informed that, not the first 3 lines, 4th line. Board was informed that a committee was constituted by such and such and such, dated 28/1/22, to review the existing recruitment rules of non-teaching employees, restructuring of non-teaching positions, and creation of posts to a certain pyramidal structure of posts across non-teaching cadre with the following members. These are the members who consider both all the professors of IIT Roche. Now, Lordship, kindly turn to next page. Clause 3, Lordship. Here the recommendation came for Precedent Register, Lordship. The observation was there, earlier position was that distribution of posts between direct recruitment and promotion in case of entry-level group A posts are inconsistent with assistant register That was 75% into 25%. Now, the recommendation is there in the right-hand side, Lordship. In terms of the MHRD letter number such and such, the committee recommended to earmark 50% of the post of assistant register are to be filled up by promotion. This recommendation is accepted by the board, Lordship. Now, 50% was post of the total post. Then Lordship may kindly turn to page 106, 2 pages. That is the same proceeding. The post which has come into existence because of this earmarking 50%, Lordship, how to be dealt with, Lordship, clause 7, Lordship, left-hand side, Lordship. Committee is of the opinion that annual performance appraisal report, APAR, evaluated on the basis of grade point is a better measure of judgment and performance of group of employees rather than absolute marks such as procedure would also ensure better model. Now, next column. Selection of candidates for promotion is being done with the following criteria. That was the earlier system, Lordship. APR marks for last 5 years at actual 60%. Performance written test 40%. The committee observed that the senior employees do not get any benefit for their long service in the institute, as there is no percentage of weightage given to address the employees' long services. Now, right inside the recommendation, the committee recommended the following modification in the existing weightage for all promotional posts, including our post. APR marks for last 5 years is 50%. It was earlier 60%. Performance in written test interview 45%. Length of service in the present post of the institute 5%. That is 5 marks. Formula for calculating the marks corresponding to the weightage 5% working is given there. Notice the change has been brought into the qualification necessary for promotional post. Earlier, the qualification did not remain. It has been changed, Lordship. Now, Lordship will turn to page 109. The last 2 paragraphs. The board was requested to approve the recommendation of the committee as mentioned above on recruitment rules, restructuring some non-teaching posts, steps towards pyramidal structure of posts, and non-teaching cadres of periodic review of the recruitment rules within a span of 5 years. The board discussed and resolved as below. This is the recommendation approval of the board. Resolve that recommendation of the committee as mentioned above on recruitment rules, restructuring of the some non-teaching posts, steps towards pyramidal structure of posts across non-teaching posts, and periodic review of the recruitment rules if required, be approved as per the details given above. So this recommendation suggested by the committee has been approved by the board. Now onwards, Lordship, this has happened on 17/6/2022, and now onwards, 50% post will be reserved for promotional cadets. Now, because of this, Lordship, because of the enhancement of 25% more, the promotional category, one new post has come into existence for promotional internal candidates. Now, this process, it was not there before this week. It has come now. Now, whether the crux of the matter is that petitioner is saying that this is not a sanction post, this post is already existing. So, because of redistribution for the promotional category, the new post has come, which was not there. For this new post, to fill up this new post, they have issued an advertisement on 12/3/2022. You will kindly see the advertisement in the petition. So this is, question is whether this is a sanction or this is that new post that has come. It can be treated as a new post which is not existing. And what is it? 12/12. Inspection. Page 31 of the writ petition. Lordship, Annex F. Lordship.
Hmm.
Indian Institute of Technology, Guwahati invites online application forms of eligible internal candidates for the following posts. Item number 1, assistant register post, 1 post. This 1 post of the assistant register has come into existence after the approval of the BOG on 17/6/2022. It was not there earlier. It was initially direct recruitment post. Now it has become a promotional post for the internal candidate. Internal candidate did not have this post earlier. So this post has come into existence only after this approval. It cannot be compared with the 4 posts that was advertised earlier. Furthermore, Lordship, as per the BOG's resolution that was created, defined qualifications are necessary for this post. It was not the same with the earlier post. For that, a new selection has to be taken up. So they have advertised for this post and applications are invited. Now, once this appointment issued, petitioner applied for this post, this new post. That 12 advertisement issued, and there's about 17 candidates appeared, including the petitioner. 11/5/2022 selection had taken place, 11th of May. And as a mandatory requirement, the selection committee immediately forwarded the select list to the Board of Governors.
Where is that?
Lordship.
Where is the select list?
Oh, Lordship. That I have stated in my affidavit, Lordship, page 78. But I read out.
No, no, where is the list?
Oh, list of candidates you applied for. Second. Isn't it? 11/22. Itu part of date. Huh? Huh?
Page 50.
11 page 51.
Don't go really. Yeah. Okay. 16th day of June. Okay. No. That is annex 9, page 50, Lordship. Page 50. This is the members who are present. Following candidates appeared in the interview. Whoever such Lordship. And item Serial number 5, one Manoj Jyoti Pathak, respondent number 7, and serial number 8, Surendra Mohan Saloi, the lead petitioner here. And select committee lordship. Next page, lordship. They have selected the respondent number 7 in the next page, lordship. Now, lordship, let's see. This second advertisement is issued on 12/10/2022. Petitioner has applied lead petitioner along with other candidates. Now, on 11/5/23, the selection had taken place. Immediately or thereafter, as a mandatory requirement, select committee sent it to the Board of Governors. As agenda item number 14. On 16/6/23, the 115 Board of Governors approved the selection. And just 2 days before that, 12/6/2023, we presume that having come to know the selection position, that petitioner was not selected, he filed his writ petition. He applied it to the advertisement, he set for the interview, then it was selection was over. Then after a month, lordship, on 16/6/2023, board has approved the selection. Just 3 or 4 days before that, after a month of the selection, May, June, lordship, 2 months of the selection, he has filed his writ petition, saying that I did not know about the waiting list of the other selection. My name was first. Therefore, this process come within 1 year. So I must be appointed, lordship. This process not even existing during that time. It has come from different sequence. Because of change of the vote, because of change of the whole structure, the new process come. And it requires new qualifications. But the logic is that selection procedure, every waiting list is connected to the selection procedure. Selection procedure is held as per a post advertised. Now, this waiting list cannot be availed of the candidates cannot avail for another post requiring another qualifications and defined selection. That will also see the conductor or petitioner that after 2 months he appeared for this, he appeared the selection. He waited for 2 months. He had come to know the selection is, it is forward to the board. He somehow managed to come to know that he was not selected. He took the plea that this earlier selection, I was in the waiting list first, it was kept secret. Waiting list is the advertisement of 5/1/22 itself says the select committee will prepare 2 lists. One is select candidate, one for voting list. You are a senior employee of the IIT, very senior. You should have inquired the position of IIT. You knew that waiting list should be prepared. Why did you not inquire about the position of the waiting list then? He said that after 1 year, he said, I did not know. You should have applied. There's no record, lordship, on the year that he made me attempt to know the position of the waiting list. It is always kept open. Anyone can see the position of the waiting list. Now, this is, lordship, a misleading statement by him to take, lordship, some advantage of his position waiting list. I'm senior employee. I know the select is prepared, waiting is prepared. So select is my name is not come. 4% if you select that they have joined. I ought to have inquired with the waiting list my position. If we kept it secret, have you made an application? It is never kept secret, lordship. This is always open for instructions. We do not publish it. We publish the other one. Now, after 1 year, when second advertisement issued, all these things happened. He said, he appeared for the second advertisement. Having come to lordship, somehow ordered that he was not selected. He said, I did not know. It was kept secret. Waiting list, it was made known that waiting list will be prepared. Immediate selection. Why did you not make me enter that time? You're not a fresh outside candidate. You are a senior person, experienced person of the institute. So this is not, this statement is not come with clean hands. So now I have now. I've already stated, Lordship, that these are our rules, Lordship. We need an autonomous body under central government. We have committed to frame our own rules. We follow our rules. We do not straight away go to the DOP guidelines when we have specific rules. And rule also, this is mentioned about the selection procedure and all these things. Now, waiting list is connected, as I've stated, Lordship, is connected to the selection process. Selection process is conducted, Lordship, to find out the select candidates which are advertisement, which were advertised the post. That waiting list cannot be availed of by a candidate for a defined post with defined qualification and defined selection process. All cannot be nullified just to accommodate him because he was first position in the waiting list. There's some sort of something which cannot be accepted, Lordship, logically. Now, as I stated already, that we sanction a new process coming at distance. These are all we generally use it, Lordship. The sanction doesn't mean strictly that post is sanctioned by the ministry, then it's come in that way. By new post sanction means a new post which was not existing yesterday has come, which has come after the first advertisement. That clause 3 says any post which has come into existence after the advertisement, 5-1 if that post for that waiting list candidate will not get any benefit. These posts has come in June 2022 when the new recommendation is accepted by the Board of Governors. New posts come which are not existing. When the first advertisement issued, is a clear, that very clearly stated in clause 3 of the first advertisement. They do not apply to the new post created subsequent to the advertisement. And these posts has come into 6 months after that advertisement. It was not existing at that time. Therefore, Lordship, that logic shown by the petitioner is cannot be justified in any manner. Now, his Lordship will kindly see the pre-Arbitrary petition. He says, huh? Page 18, Lordship. Page 18, page, Lordship, 23, Lordship, of the writ petition. It is therefore prayed that this honorable court may be graciously pleased to admit his petition by issuing a rule upon the respondent to show cause as to why a writ in the nature of certiorari and other appropriate writ order substances should be issued to set aside and quash the recommendation of DPC dated 11/5/23. That is the second selection, Lordship. In pursuance to the internal advertisement dated 12/12/22. The recommendation to be set aside. So for the same relates to selection of the additional vacancy of the position registered in the such and or to set aside was the impugn letter under reference, that is 9/6/23, Annexure 7, issued by the Register Indian Technology forthwith, and to set aside and quash the impugn approval of the recommendation of the selection. This challenges the recommendation of the second advertisement for second selection. It did not challenge the advertisement. Second advertisement. The selection had which had taken place pursuant to the second advertisement. That recommendation is challenged, but it has not challenged the second advertisement. The second advertisement was issued to fill up the post, which is a newly created post dated 12/12/2022. He's not challenging it, Lordship. Therefore, his prayer, the recommendation should be set aside. It's got no logic. Therefore, Lordship, my humble submission is that I have nothing against the petitioner. He is also an employee, a competent man. But position the rule should be established so that in future there will be no complications in administrations. He has not come with clean hands. He knew it everything. He taken this new plea only to sort of take advantage of this position earlier. Now about what were secret documents and all these things, what he stated. But you kindly see In what reference we said it? At page 39 of the writ petition. The representation given by him to the director lordship. I had submitted an application on the above subject to the register such and such. I have not received any reply. 3, that I am entitled to be considered such and such. 4, it is humbly needed to be pointed out that my case alone, their provisions have drawn up panels such and such. Therefore, lordship, for the parity, fair play of and justice, it is required that same official treatment be extended to me, being serial number 1 of the panel, that's waiting list, which remain valid and which is not known to me. This is unbelievable, lordship. Owing to the BOG's concern, minute kept as a secret document and not circulated. The waiting list, lordship, you have declared the waiting list has to be prepared. He said you kept it secret, then why didn't you apply for it? Why didn't you? There's no move. He made it officially to know about the waiting list positions. He said you kept it secret. Now, this is his secret, term secret is by him only. In reply, lordship, at page 48, we have given the reply, where a new plea is sought to be taken up by the petitioner. Lordship. Second paragraph, lordship. Your in response to your later there, such and such, your appeal is under consideration at the office raised such and such. Third paragraph. Further, in your appeal to the register in charge, you wrote, having somehow managed to come across the BOG's minute high deduction of such and such. Item number 13. In the appeal to the officiating director, we have mentioned BOG concerned minute kept a secret document and not circulated. This was stated by him. The waiting list is a secret document, he not circulated it. In that reply, we said, how have you come to know a secret document? In that case, that is only nothing, no legal value, lodge. He said this is kept it secret, waiting list. He never made an attempt to know about it also. Normally, it is always there in the office, anyone can find out the position on the waiting list. He said you kept it secret. Then we said that, then how have you come to know that you kept it secret? It is only lordship for argument's sake only. It's got no otherwise any meaning. Therefore, my humble submission, lordship, is that petitioner has not come with clean hands and he has just come to take advantage of his position. He created a new plea. Therefore, lordship will decide whether he is entitled to this new post or the respondent number 7 who has been selected lordship for this new post in the proper procedure. That your lordship decision will abide by lordship decision. The gainer or loser is the respondent number 7, not us. We only want that legal position to be established.
What is then the records?
Record Dylan. Huh? Annexer 14, the page 14, lordship. Is a page was leaking. I've given all the marks, lordship. At down to annexer 14, these numbers we have given only for reference lordship. Second selection or selection cut-off date 1/1/22.
Yeah. Mark. Paper.
Well, kindly see that respondent number 7 in this selection got 79.77. And the writ petitioner at the last lordship, he got
Annexure?
annexure 14 lordship of the records. Item number 5 is the respondent number 7. Serial number 5. And serial number 8 is the writ petitioner. So the marks obtained by the respondent number 7 is 79.77. And the writ petitioner 64.0. The other records are also there, lordship. That's a clearly stated on what basis marks have been given, Lord.
There's a note of dissent also.
Lordship?
There's a note of dissent by DD,
Yes.
Annex 14.
Page 14. Lot of dissent is there, Lord.
My instruction, I have not put it in here, my lord, that someone from that DPC, my lord, had also walked out. Maybe your lordship is referring to that. That is my information only, but I have nothing to show.
What is DD?
Deputy Director. Lord. Deputy. It is. Lot of dissent. I do not agree with the marks. Marks. Examine it. Whatever. My respondent 7 will show you. Is the actual Kenya or Luja will be respondent number 7.
Wait, please, your lordship. My lord, I file my affidavit, my lord. My affidavit is start from 115 to 134.
Page?
Page 115 to 134.
Yes.
So your lordship kindly see 132, page 132. Page 132. So 132 is my appointment letter. With reference to the Hazel Lordship, what is page 132?
Yes.
That is my appointment letter with reference to your application of the post of assistant register in presence of the institution circulated so and so. And subsequent interview held on 15/5/2023, I am glad to inform you that you are promoted to the post of Assistant Registrar on recommendation of the Selection Committee and approval of the Governor of the Board of Governors of the institution with the following condition. So that was my appointment letter, and very next day, my lord, same day, my lord, I have joined, my lord. 133 is my joining letter. 133, my lord. So there is no stay order also here in this case, my lord. So I join in post, my lord. Now, my lord, your lordship kindly see what is his pair, my lord. He, my lord, did not challenge the interview, my lord. Your lordship kindly did not challenge the advertisement, my lord. He appeared, rather he appeared in the in pursuance with that advertisement, he appeared. After appearing, when he came to know that he is not going to succeed, then only after 2 months he filed his petition, my lord. So your lordship kindly, his case is that earlier advertisement, his name was in waiting list, and it waiting list already, my lord, your lordship kindly see the 4 posts was advertised, only 4 posts. So as per my lord, FRBM Act, only 4 posts advertised and 4 posts, my lord, name of the 4 person have to be recommended. But FRBM Act is not applicable to the IITZ, my lord. That's why their internal arrangement is there. Their rules are there, my lord. That's why clause 3 of the advertisement was applicable. The clause 3 of the advertisement clearly mentioned that your lordship kindly see page 27 of the writ petition, my lord, which already, my lord, my senior friend argued on that point, nothing left for me. Even then, my lord, I just pointed out one thing, my lord. Page 27, my lord, clause 3. First advertisement, my lord. So he's taking benefit of that. The panel selection waitlist drawn up by the Department Promotion Committee, DPC, as per the government norms, will be valid for 1 year. If any post fall vacant within 1 year from the DPC meeting, its same will be filled up during the waiting list as per category. This will not apply to the face sanction post made after the advertisement. Candidate will be selected from the said recommendation list. Now there is 2 parts. Normally, my lord, what happened? Suppose these 4 posted advertisement and 4 persons who have joined. If someone died, someone retired, or someone resigned, then waiting list candidate will be, my lord, fill up that post. Because interviewer held for that particular 4 posts, my lord. That within 1 year, some new post was, my lord, sanctioned. Then that will not cover. That next line is there, my lord. That is newly sanctioned or newly created post, that will not applicable. That's why the second advertisement, my lord.
What does it actually mean? This will not apply for fresh sanction of post.
Exactly, my lord. Fresh sanction post means, my lord, the post which was occurred after that. Your lordship kindly regarding that already my learned senior friend explained, because board of meeting has decided because of the earlier it was 75-25, 75 direct, 25 promotion. After the board meeting, they decide that because there's a demand of the internal committee. So they decide, yes, now it will be goes up for 50-50. That point when the decision is taken, that from that point of time, my lord, that post is, my lord, record. So that, my lord, who is the post which was yet to born, how they can be selected prior to that, my lord. So that's why I'm submitting, my lord. This is, my lord, he cannot take benefit of this, my lord. Even then, when he came to know, my lord, he should have, my lord, cancelled, silenced the advertisement, my lord. He has not silenced the advertisement, lord. Rather, he appeared. Your lordship kindly, my lord, I made a written argument before your lordship, my lord, that. So, my lord, your lordship kindly, that my written argument I made, my lord, argument, my lord. My contention is, my lord, that page, second page, my lord. Regarding, my lord, approaches, my lord, petitioner, my lord, a preliminary objection, my lord. After unsuccessful, my lord, he approached this honorable court, my lord. This is a settled principle of law, my lord, and that regard there is a judgment of 2015-11 SCC. in this context, my lord, I would like to place one judgment, my lord, 2015, 11 SCC, page 493, my lord. In para 17, may I read this, my lord, very distinctly, my lord, that is squarely covered in my case.
You've given the list.
Yes, I have given in that, yes, I have given a 1590. You know, my lord. Huh?
Not given.
My lord, one para, it will be enough to my lord, if your lordship, my lord, para 17, my lord.
Get a copy.
So that, your lordship, same situation here also, my lord. So my already, my lord, my senior pen, my lord, everything has been explained, my lord. I fully adopted that argument, my lord. But one thing I am submitting, my lord, here in this case, my lord, my submission before your lordship, that he has not challenged the validity of that challenged the advertisement, my lord. And the post which was second advertised in the second advertisement, my lord, he cannot take the benefit of the clause 3, my lord, because it is a newly created, newly sanctioned post which was my occurred after the first selection is over. So that's why selection and appointment is over. So that's why, my lord, he cannot claim the benefit of the clause 3, my lord. And it is already cleared from the record, my lord. The post is, my lord, created afterward. So that's why, my lord, he has no case at all, my lord. After, at best, he should have challenged, my lord. When he came to know that, my lord, he should have challenged the advertisement, my lord. Without challenging the advertisement, my lord, the result you cannot challenge. That's why in that para 15 very clearly mentioned that you are waiting for a result, and then when you are came to know that you are unsuccessful, then you file this writ petition. So my submission before your lordship, my lord, there is no merit in the writ petition, my lord, the liable to be dismissed. Your lordship, kindly that I have already submitted my written argument, my lord, and clearly mentioned everything. Yes.
Well, I'll try to be short, man. First of all, my lord, I am not challenging my rejection in the second selection, man. Rather, I am claiming my entitlement on the basis of my position in the first selection. In pursuance to my lord circular dated 5/1/22 to the vacancy that arose in the same vacancy year, man. Let me be clear on that, my lord. I'm not trying to derive, my lord, any gain from the subsequent, my lord. And I explained.
Whatever you're trying to say
Yes, my
is
lord.
on the basis of clause 3
Yes, man.
of the
Yes, man.
circular.
If it is not a newly sanctioned post, I'll come to that. I'll place the rules. And if it didn't have the financial approval, it couldn't have been a newly sanctioned post, my lord. Redistribution is something else. Earlier, because the cadre strength was 16. When it was 75%, 25%, direct recruitment side, my lord, that their proportion was more, man. When it was made in the middle of June, in 22, as per some central government directive, my lord, making it 50%, 50%. So one post from the side of the direct recruitment came over to the cadre strength did not, my lord, increase or my lord, lost its strength, my lord. It remains same, my lord. So these are all existing posts, 16 number of posts. And the exemption in the general information, my lord. That refers to a new sanction, my lord. In that case, my lord, it was not there before the earlier DPC. In that case, they will go for a second DPC. But otherwise, because the purpose of making that waitlist method, they are trying to make out a, my lord, case that this waiting list can be used only for some vacancy in the main list, my lord. Suppose somebody didn't join, my lord, someone expired, my lord. Someone may not accept, my lord, out of that four. In that case, that wait list will do. But the rule is this, my lord, I'll just place it. But before that, my lord, I said I have. They say that I have come with unclean hands, my lord. So therefore, I would like to place my pleadings in my para 9, my lord. Paragraph 9, my lord.
Another
It's-
thing,
Yes,
you
my-
can read
my-
that,
my-
just
my lord,
keep in
my
mind
lord.
that after you put in the wait list,
Yes, my lord.
there was a change after the recommendation of the committee
Yes, yes.
from 75-25 to 50.
50-50.
Plus, along with that 50-50, the eligibility criteria
Yeah, has
also
been
has changed.
I'll come to them. They cannot change, my lord. If that is within the same vacancy, they cannot. The rule says, man. Rule
No,
says
no,
that.
I'm
Yes,
just
man.
eligibility criteria has changed. After that, the vacancy arose.
Yes, man.
Correct.
No, vacancy arose from before they changed to fill up that they changed the eligibility criteria.
No, no, no. After they changed the eligibility criteria, only then the vacancy arose.
No. The vacancy has to arose earlier, my lord. Then they can change, my lord. But the rule says,
No, when 75-25 was in operation,
yes, my lord.
there was just these 4 posts. There could not have been another
My
one
lord, the
post.
records would show even
But
there.
when 50-50 came, another post
No,
came.
my lord. So, my lord, post was there, but it was on the direct recruitment side. my
That
lord.
is what I'm
Yes,
saying.
man.
So from
But
the
it was
direct,
not sanctioned,
whatever it is,
Yes, ma'am.
from whatever it is, the post came.
my lord.
So you're vying for this post.
Yeah, that post, man. Because
But for this post,
yes, my lord.
the criteria has also changed.
They cannot change.
That
you're-
you have to,
yes,
you
yes,
have
ma'am.
to clear.
Yes, ma'am. But
Okay.
I'll also place my lord in a second. My lord, I qualified. My lord, last 5 years I had APAR points of 8, my lord, 80%. And their requirement is 50% or something, 60, my lord. Last 5 years. So that way, my lord, I am qualified, my lord. I am one of the senior most persons. My credentials are good enough. Your lordship has already noted some dissent from someone, my lord, in that committee meeting, man. But anyway, my lord, be that as it may, let me just place my case, man. They say that I knew it already, but then I made out a case. So that, my lord. Para 9, my lord, in my writ petition. Page 13, my lord.
Yes.
The petitioner may state that being aggrieved and dissatisfied with the action of the respondents impugned in this writ, the petitioner submitted a written representation before the registrar IC IITG on 24/5/23, which is my knowledge, my lord, date of knowledge, my lord, stating that the subsequent interview of a single post of assistant registrar falling vacant within the calendar year of 2022 was not only illegal but also violative of the IITG BOG's directives. In his representation, petitioner stated that if he had known about the minutes of the DPC dated 18/2/22 before applying in connection with the subsequent advertisement and appearance in the interview, he wouldn't have applied. Rather, he would have applied for considering him for appointment in the fresh vacancy of assistant registrar being placed in serial 1 of the recommended panel, which was valid till 17/2/2023, man, because that list was valid for 1 year, man. That is why I said that. And then, my lord, para 12, my lord. Last part, my lord. Para 12, my lord. Page 17. But in the instant case, the concerned respondents failed and are neglected to upload the recommendation of the DPC dated 18/2/2022 in their website, compelling the petitioner to take part in the fresh DPC dated 11/5/2023 for lack of his knowledge that he was already empaneled in the top position of the extended panel, entitling him to be appointed to the additional vacancy of assistant. Then para 13 also, my lord, that the petitioner begs to state that the contents of the aforesaid letter dated 9/6/23 also establishes the fact that the concerned authority admitted the fact that the said information of recommendation of the name of petitioner at the top of the panel was kept concealed in violation of the established practice with malafide design to the illegal deprivation of the petitioner. That I will explain. Your lordship will kindly come to annexure 7 once, my lord.
Which,
It has been, your lordship has already been taken to, what quarter? 8. Huh? This is their reply to me, my lord. Yes, my lord, page 48 it will be, my lord. Which is their reply, my lord. 9-6, your lordship has already seen it, but I'll just reiterate my one. Last 2 paragraphs. Further, in your appeal to the registrar in charge, you wrote, having somehow managed to come across so and so in appeal to officer. You have mentioned BOG's concerned minute kept as a secret document and not circulated. My lord, they themselves has noted, my lord, in writing, my lord. As per your letter, you have managed to come across above referred confidential documents. Suppose I had applied, my lord, for waiting list. Normally, people do not apply for waiting list. It comes out, my lord. You have conducted a selection. Main list, wait list, all are published, man. All are circulated, man. And this is a premier institution, man, with a name to it, IITZ. What is happening inside, man? And it is not a fact that they are uniform in their actions, man. The very same selection, my lord, the respondent number 7 has joined as assistant registrar, and the post of section officer, which he held earlier, my lord, in the same bracket, my lord, that was given to Opurbo Bhuya, my lord, from the drawing him his name from the wait panel, my lord. Let them place the records, man. I'll withdraw my case, man.
what is it?
My lord, this same practice, my lord, appointing someone from the wait panel to additional vacancies, my lord, they have been following. Even after the petitioner was denied, one other, my lord, Opurbo Bhuya, he was appointed section, my lord, that is not on affidavit, my lord, because I have come to know about
No, after the
Yes, my lord. The same post which was vacant.
after the second circular.
Yes, my lord.
Second
Yes, my lord. After the second.
which the private response number 7 was appointed.
Yes, my lord.
After that, another vacancy arose.
Yes, my lord. That vacancy was in the post of section assistant. Section officer. Section officer, my lord. Section officer post was given to my lord. My lord, it was held by, my lord, my instruction says, by the respondent number 7 earlier. Respondent number 7 on his recommendation, my lord, an appointment as assistant registrar, my lord, that post fell vacant. That post was filled up by that incumbent, this gentleman, my lord, drawing his name from that wait list, man. My lord, my submission may be recorded since I am not on affidavit, man. And let them show from record that did not follow this proceed, my lord, this proceed. It is there, my lord. I'll place my lord, they refer to their recruitment rules. Much has been said, but they have failed. It is not there in the recruitment rules, my lord, how they have to fill up. And direct recruitment, they may have rules, my lord, but so far as DPCs are concerned, these are standard norms, my lord. Not only IITZ, even other public sector undertakings in the central government, they have to follow these norms. And these are the norms. If that vacancy arose, my lord, the only distinction is, your lordship, in my humble submission, your lordship has to see is whether it was a freshly sanctioned post, as they have in letter and spirit have stated in the first circular, my lord. The first circular, my lord, your lordship, it also says, the first 5.1, it also says, my lord, it also says, it refers to Government of India norms. It doesn't say recruitment rules. Your lordship will see at same clause 3. It says Government of India, which is missing in the second one. Your lordship will come to the second one, 12.12. It is not there. 12.12, it is not there. Go to page number 2. My lord, that page 30. Huh? No, 12. Yes, 31. My lord, here, my lord, it will be page 33. Clause 4. Clause 4. The panel drawn up by the page 33. By Department of Promotion Committee, DPC would be valid for 1 year. The date of commencement of validity of the panel shall be the approval date of the competent authority on the panel forwarded by DPC. Any post held vacant during this period, candidates will be promoted as per merit and considering category. This will not be applicable in case of fresh sanction. This fresh sanction has remained, my lord. So that post has to be sanctioned afresh, my lord, with financial approval from the government. A post which takes place after the advertisement, in case there is a tie DPC. So, my lord, but that reference to Government of India norms is not found here. But first circular, my lord, my right flows from the first circular. And Government of India norms are these, man. Department of Personnel and Training, man. I'd like to read out, my lord. And my lord, one other thing is very relevant. They have said that assessment metrics and all have been changed, my lord. Your lordship has raised it. Your lordship will kindly come to clause 1.
Okay, we'll continue
At 2, man.
Number 27.
Item
27 of today's list. Possibly a matter would not reach me. I have some personal problem. So let the matter be listed on Tuesday, next week.
Okay.
I have taken consent.
On request made by Mr. A.K. Progress. Then a counsel for the petition. Based on
Tuesday, madam.
27th.
My lord, oblige.
I have a similar prayer with item number 14. Can it be taken up next week?
Okay, on request made by RD. Then a counsel for petition. Based on 5th March.
My lord, can the similar matter order be passed for item number 20 also, 21? 21, my lord. On orders, my lord. Next Tuesday.
You are appearing for?
For the petitioner, my lord. Next Monday or Wednesday, my lord.
Okay. Yeah, Mr. S.P. Sharma.
Yes, my lord.
On request made by S.P. Sharma. When do you want?
Next Monday.
Next Monday will be bit difficult. 28.
28. Okay, man.
Item 5 and 6 to continue.
Mr. Goswami, you were saying that they've appointed someone as a section officer
Yes, my lord.
pursuant to the, was there a wait list?
He was drawn from the wait list, my instruction.
Is that correct, Mr.
Opurbo, yeah.
Yeah, that is not part of
Records,
the pleading.
records,
Suddenly he's just coming out with this. But is it correct? But is it correct?
I have to confirm.
Even my lord, in my writ petition, your lordship will kindly, I have given a panel, my lord. There are other cases. They are following this procedure. Your lordship will
So
kindly.
have you at least mentioned it in your writ petition?
My lord, I did not ever. Opurbo Bhuya is because of Opurbo Bhuya is recent, very recent. The same interview selection as in which I had appeared, but I am not really laying any claim on that. And my the client of my dear friend, my lord, appeared, my lord. It is from that circular, man. 12. But before that, my lord, I am placing this. Your lordship will kindly, in my writ petition, I have already annexed. They are following this procedure.
Which?
This is for them to follow it, and they are following it. Why they are trying to, my lord, deprive me of the benefit, I do not know. My lord, annexure to page 40, my lord, of the writ petition.
Yes.
At the bottom, my lord, serial 15.
Hmm.
Mr. Lolit Soikia, my lord. He is a candidate drawn up from wait list and appointed as senior superintendent. My pleadings are there, my lord. Senior superintendent. Then next page, my lord. Mr. Supriya Das.
No. This is a wait list of what?
Wait list of that particular interview, my lord. I have my pleadings is at my lord page
wait list of
for the post of senior superintendent, not assistant master, senior superintendent.
no wait list of the first circular. 5/1/2022. That's a different advertisement.
Totally different. Different time.
My lord, it is
These are
for,
different
my lord,
rights.
they have not replied to this. It is for them. They have not denied this. They have not placed the records, my lord. It is for incumbent on them, my lord. They are the respondent authority. We rely on their records, my lord. They have not. This is,
This list.
but
Yes.
but they have not said that they have not denied that they have appointed these people, my lord.
Where's your statement?
My lord, that is at page 40. Just 5, 6 series. Just a moment. My lord, I have stated, my lord, you would have applied, my lord, para 10, my lord, that the petitioner makes a state that the petitioner upon not getting any reply, page 14,
Page?
14 of the writ petition.
Yes.
That the petitioner upon not getting any reply from the registrar IC, IITZ file another representative before director IC of IITZ on so and so through proper channels stating entitled that he did not receive any reply and that he was entitled to be considered for the post of assistant registrar IITZ in terms of OM number so and so dated 10/4/85, and that while in his case the provisions for appointment of candidate from drawn up panel to fill up subsequent vacancy during a period has been deviated, and enclosed documents clearly showed that in appointment to the post of senior superintendent, level 8, the panel kept on reserve was utilized to fill up subsequent vacancies occurred during the validity period without drawing any fresh DPC. This I have stated, this I had represented with this annexer and that
What
annexer.
have they replied in their?
Yes, my lord, para 10 replied. 2 to 6. 2 to 6. 2 to 6 है 1 to 6. Again. My lord, in para 11, my lord, of their affidavit, the statements within para 9, 10, and 11 of it, which are partly matters of records. Deponent however states that the representation submitted by the petitioner is devoid of any merit, and substance in view of the statements made in the foregoing paragraph. In this regard, deponent makes reiterated that the IIT Guwahati being an autonomous institute, DOPT guidelines are not directly applicable for the institute. The institute follows recruitment rules approved by the BOG. The deponent further affirms that the institute has strictly followed the relevant rules. The statements are very vague, madam, I must say, and they have not been able to show the which recruitment rules, madam. Even if recruitment rules are there, my lord, let us assume, my lord. Even if these are standard norms for DPC, man. And my right flows from that circular. That clause, my lord. If it is an existing post coming from the direct recruitment quota to internal promotion, and it is not a sanctioned post, then my lord, it should have gone to the panel already done. Otherwise, what is the use of that exercise? And the rule, my lord, I will now place the rule. My lord, this is the OM, my lord, dated 12th and 19th. No? I'll follow procedure.
Which OM?
My lord, OM number, my lord, 220. And I'm placing this before your lordship. The DOPT guideline, Department of Personnel and Training, Central Government. Somewhere it is marked, your lordship will kindly ignore that. Huh? Huh? Your lordship will kindly come to 4 plus 4.4.8. It provides for the method of preparation of year-wise panels by DPC where they have not met for a number of years. Not in this as in the present case, my lord. Then below, my lord, OM number 22011, my lord, stroke 4 stroke 98, establishment D dated 12 to 19, and something, my lord, which is left out, my lord, in the photocopy, but it is a continuation, my lord. 449, cases of occurrence of additional vacancies in a year.
Hmm?
At the top, my lord, 449,
Where? Oh,
cases of occurrence of additional vacancies in a year. Where a DPC has already been held in a year and further vacancies arise during the same year due to death, resignation, voluntary retirement, etc., or because the vacancies were not intimated to the DPC due to error or omission on the part of the department concerned, the following procedure should be followed. 1. Vacancies due to death, voluntary retirement, new creations. New creations is sanction. New creation is not redistribution of post. Cadastre remains the same. This is not new creation. This is not sanction. This is redistribution from one quota to the other. That is my humble submission, my lord. So in case of death, voluntary retirement, new grade, etc., clearly belong to the category which could not be foreseen at the time of placing facts and materials before the DPC. In such cases, another meeting of the DPC should be held for drawing up a panel for these vacancies, as these vacancies could not be anticipated at the time of holding of the earlier. This is perfectly in consonance with the clause 3 of the general information manual. If for any reason the DPC cannot meet for the second time, the procedure of drawing up of year-wise panel may be followed when it meets next for preparing panels in a so and so. Now here, my lord, A, B, C, the relevant para will be D.
but Goswami, you have not referred to this in your main argument. Now they have to answer back, isn't it? Now we'll
No, I have quoted this. In a writ petition, I have quoted it. This is my argument. Lordship, possibly, my lord. It is very much. This is the, my lord, basis of my of my case, my lord.
you're bringing out new issues.
No, para 7, my lord. Para 7 of the writ petition is this only. 449. Exactly this, my lord. Writ petition may kindly be seen once, my lord. I have quoted it. This one. My lord, I am reading out. The officers who have already been empaneled or placed in the extended panel but could not be promoted due to these vacancies not actually being available need not be reassessed by the supplementary DPC as the assessment matrix remains the same. They may be appointed against the additional vacancies of the same vacancy here.
But however, it says as the assessment matrix remains the same. In this present case, the assessment matrix
They have
is
changed
different.
it. They have changed it to avoid it. But for the same vacancy here, they cannot do it. They couldn't have done it. It is not provided here. It is not provided there. The advertisement, my lord, whatever they cannot get back from what they.
See, the issue is this. Yours is a simple matter.
Very simple.
First circular, 4 vacancies of assistant register, 4 appointed, you were put in the wait list, number 1. Thereafter, the committee made some recommendations. BOG accepted the approval. And with that acceptance, 1 post which was from the direct recruit quota, that 50-50, came into
the share of the internal promotion.
For the internal promotion, right? So to fill up that post, now the criteria has changed.
Yes, selection criteria has been changed.
Criteria has changed.
My lord, that they have changed it, my lord.
No, they
Yes,
have changed it. Now, when that panel of your panel of wait lists was on the basis of a different criteria.
Exactly, my lord.
Now, can we apply you to that post which holds a different criteria? That is the
No, my lord. Now, why it is not a different post, my lord? They may say, my lord, they give all the colorings, my
No,
lord.
no,
they can use.
whatever
But
it
your
is,
lordship will
one factual aspect is criteria has changed that nobody can deny it.
My lord, I am not laying my claim on the basis of the second everything. Maybe, my lord, they have changed their assessment criteria. I am this is solely based on my right flowing from the first advertisement.
No, Goswami, you don't understand.
My lord.
The first, the one post of assistant register came because of the change in the criteria. 50-50 plus eligibility criteria.
Right.
All right.
Right.
Otherwise, if that 50-50 was not changed, that post would never have come.
Oh, would never have come.
Correct. But then when they made the recommendation of 50-50 from 75-25, this one post came. So along with that recommendation of 50-50, they made some further recommendations with regard to eligibility criteria, if I'm not wrong.
Well, here the issue is,
Along with that post comes the criteria also. How to be considered for that post.
well,
Or the recommendation of the committee has already been accepted by the BOG.
the guidelines say that the assessment metrics remaining the same. That means within the ordered vacancy year, they
No,
cannot
see,
change it.
let us read it properly.
Yes, my lord. And I will show from my documents, my lord. Of their minutes
It says
only.
need not be assessed by the supplementary PPC
Yes, my lord.
as the assessment metric remains the same. Here in your case, that is not the issue.
To my lord, get away from this, my lord, the tidings of these provisions, they have come with that saying that the assessment metrics has changed. Now, what has it changed, my lord?
He has not sell in the advertisement. He cannot make any submission on that.
You'll come
He has
later.
not sell in the
You'll
advertisement.
you'll come later, huh? You've been given enough opportunity. My lord, I just pointed out that clause 1 of the general information in both the cases.
Hmm.
If they had changed the assessment criteria or assessment metric, then my lord, cutoff date for counting experience is 1/1/22 has remained the same in the new metrics also. Why do they say that they have changed it? Where is the change?
What cutoff?
My lord, your lordship will kindly come to the both these circulars once more, my lord, 5-1 as well as my lord 12-12. Page, my lord,
27.
page 27 is one. Your lordship at the bottom, general information. Clause 1, my lord, cutoff date for counting expense is 1/1/22. Your lordship will see, this is 1/1/22. Then, my lord, your lordship will kindly come to the next advertisement, that is at page 31. Next circular, man. Annexure 3, my lord.
Hmm.
The relevant part is at page 33. 2 pages there. General information, cutoff date for counting expense is 1/1/22. Now, why they say that they have changed it, so that, my lord, I cannot come in? But they have kept it all the same. That is my case. I may submit my, your lordship will go and kindly scrutinize the records, my lord. And they have specifically used the word Government of India norms in the first one, second one, it is not there. Then third, my lord, they have used the word sanction. They have not said created or arising or those words are not. Sanction, my lord, we are students of law, my lord. We understand if it has to be sanctioned, the financial approval has to be there. Now, these are the documents, my lord, which will show that nothing was sanctioned. I'd like to place it before your lordship, my lord. These are, my lord, annexures of minute of the 111 meeting of Board of Governors, date and time 17 June. Same one, my lord. This will show the cadre strength. Move copy to go. If it is to be sanctioned, my lord, approval will be there before that proposal has to be sent. If the records, my lord, show that, my lord, then I'll accept it. Your lordship will see. Annexure 38 of that these minutes, my lord. Posts are given on the left side. Assistant Registrar. The GP, I do not understand, my lord, what is this? But then, my lord, recruitment method, direct and promotion. Group A, pay matrix level 10. Present sanction strength, 16. Man in position, 11. They were filling up 4 posts at that time, so. 4 plus 1, it will be 5. And proposed strength 16, man. They did not even propose. Your Lordship, I'd like to place the distinction. And in section officer, next, your Lordship will see, section officer. They have created all this at the time. Present strength, sanction strength, 0. They propose 17. In the case of assistant registrar, the figures have remained the same. If in that meeting, this is of that June, my lord, same meeting, 17 June. How could they say that this was a sanction post? It was an existing post on that 16, my lord. Whether this was this side or that side, and that is not clear. Circular does not say that. Circular says if a new post is sanctioned, with all the corollary, my lord, tappings of newly sanctioned post, my lord. Proposal, approval, financial approval.
So for what sanction is concerned,
Yes, ma'am.
they have tried to explain it in the affidavit.
Yes, ma'am. They have, in fact, the very first preliminary affidavit, they said the post is a sanction post, newly sanctioned post. That is their stand. In that affidavit, that assessment matrix was not there. Preliminary affidavit, your lordship, I placed it in my, when I started my argument, in the first case, in the first petition, my lord. There, my lord, this was that it is a newly sanctioned post. And so, as per clause 3 of the general information, I am out. That was the case, my your lordship can very well, I can place it with particular relevant paras.
In the first case.
Yes, first case, my lord. One period. That is the preliminary. Preliminary affidavit, my lord. 26/2013, we received. Has your lordship?
Yes.
There, your lordship kindly come to clause 3, Roman 5, small, C, page 62.
Para 3.
Para 3, yes, my lord, para 3. Page 62 of that internal paging, my lord. I am reading out my subsequently Board of Governors IIT Guwahati in its 111 meeting held on 76/22 has sanctioned a new post. That is why the records were, my lord, called for. Man. This was the reason. Man. The court wanted to see whether that post was a newly sanctioned post or already existing.
Yes, Kakuti, that records is not here. Page 62 of the first petition.
Proceeding to the court, or that was held on 17/2022. That contains everything.
Let us see that minutes is here.
Page 103 of my affidavit, lordship.
Which affidavit? In the second reading?
Yes, second.
Page 103. Yes.
On the second part, based on the examination by observation, the committee recommended as below. These are the records, which is that on modification of recruitment rules.
Where?
Clause 1,
Page number.
page 103. First question got to be based on the examination of the committee recommended as below. 1, on modification of recruitment rules. These are the recruitment rules which are modified. How this process come into existence is because of these proceedings. Then
No.
clause 3.
1 minute.
Clause 3, next page. 104. distribution of post between direct recruitment and promotion in case of entry-level group A post are inconsistent with the assistant register. Assistant executive engineer, lordship here. So they suggested 50-50. Because of these, but these are the development of the records.
No, your affidavit in the first fit petition, preliminary affidavit,
Preliminary.
page 62.
Cross C, lordship.
Clause C.
Cross C, lordship. Subsequently, Board of Governors, IIT Guwahati 111 meeting held on 17th has sanctioned the new post. Sanctioned the board,
And sanction the new post. Where's the sanction in these minutes?
the sanction, I mean, the day it was approved, post got, one new post has come into existence for house on the side. We mean that, but sanction is not strictly legal, that terminology. We said, moment this proposal has been approved by the board, board proceedings have been approved, automatically the post has come to existence. The board has approved this suggestion, automatically post has 50-50 suggestion, automatically a post has come into existence.
Already existing post, how can it come to existence? Already existing. In the
Because initially, direct recruitment post will be a same register. Direct recruitment post, now it has become promotional post, lot of differentiated characters. Now, moment the board approves this proceedings, this recommendation approves, automatically posts come into existence for in the promotional sites. Post may be SL registers, but they have two different categories, direct recruitment post and promotional. And the moment the board has approved this recommendation, automatically, because of the increase of 25%, these posts has come to existence. This we are saying that new posts are sanctioned for promotion internal candidates.
No, but your language is different here. Here it says the BOG has sanctioned the new post.
So automatically BOG has approved this recommendation. Post, meaning that the post, a new post has come, that has been approved by the BOG automatically. Because of the approval of the BOG, the post has come into existence. Approval, the board accepted its proposal, board approved it, automatically a new post has come into existence in the promotional sites. That's what we meant by the sanction. The BOG is our ultimate authority, BOG has sanctioned it. That is my submission.
Also, my lord, paragraph, page 58 of the preliminary affidavit. About the middle portion, my lord. Therefore, the claim of a waiting list candidate would not be valid against any new post. This is their language, which is sanctioned. After the above circular number, so and so dated 5-1, it is the advertisement circular. The above clause 3 of the general information is reproduced herein below. Same that clause is reproduced. Wherein it is that this will not apply for fresh sanction of post made after the advertisement. Candidates will be selected as per recommended list. So, on their own, my lord, their own pleadings, my lord, I am saying that they are either trying to play mischievous role or their records are not sufficient to show that this post is an already existing post, which they are trying to show as a newly sanctioned post. A newly sanctioned post, my lord, it's sanctioned. The word is used in the same board circular sanction. That we are also finding in, my lord, my lord, in this second, my lord, advertisement also, my lord, in my read petition, page 31, sanction. They have not said, my lord, anything otherwise. And their affidavit, they have said that yes, if it's a newly sanctioned post, so I will not get it. Now they are shifting their stand. They are trying to improve by filing another affidavit. They want to shift their stand and change their argument. And that is not allowed under the law.
See page 33,
My lord,
clause 4
my lord.
of general information. I think this makes it more clear.
Panel drawn up by Department Promotion Committee PC would be fixed for 1 year. Date of commencement of validity of the panel shall be approval date of completion. If any post falls vacant during this period, candidates will be promoted as per merit and considering the category of the vacant post. This will not be applicable in case of fresh sanction of post which takes place after the advertisement. In case,
So according to them,
Yes.
this sanction, it does not mean a fresh new creation of posts,
yes, madam.
but it means a vacancy.
Yes, madam. That is their argument. That is what they,
So this is what this line is making it little clearer, I think.
that is what they, that is why that records ballot, whatever they have placed, whether this post was a sanction post or something that came over. And it was already there in the existing cadre. The document that I have placed of the BOG meeting, madam, just now, madam, it shows that strength has remained the same. And there was no proposal for a new sanction.
No, obviously strength will remain the same because
Yes, ma'am.
1660.
Yes, yes, that's
Only that 75-25 was changed to 50-50.
what.
So when that 50-50 was changed,
My,
one vacancy comes from the internal promotion.
for in favor, for madam, from the direct recruitment quota.
From
So
the
your
direct-
lordship will have
So
to,
that
madam,
is not that is not a fresh sanction,
Not a
like
fresh-
in a
not a new
normal
sanction.
legal term,
Huh.
but is a fresh, is a vacancy that arises.
my lord, we have to go by the provision, but not by the language of their affidavit, my lord. Whatever they say, my lord, your lordship will kindly go, whatever they are in the records, on the basis of that, your lordship will decide, my lord. And their own stand in the preliminary affidavit, they said it's a newly sanctioned post. If it is a newly sanctioned post, my lord, the records will reveal. That is the ground they have taken. Assessment criteria, my lord, your lordship, because my claim is not there on the basis of the second advertisement. That I have made myself clear, my lord. If I am entitled to get this post on the basis of my being in the wait list of the first, then it is good enough, my lord. They themselves admitted that this was kept confidential. So therefore, I didn't have any reason. Now they are saying, why did not you apply under the RTI? Why didn't you apply? Well, who applies for a waiting list, my lord? I am not on waiting list, my lord. This is a problem. And supposing I had applied also after they have said that this is confidential piece of evidence in their own document, my lord. They have possibly rejected that they would have possibly definitely rejected my claim, man. But that is the reason why I had to go for the second this thing. And like my friend, my lord, Mr. Mohanta saying that being having come to know that he will not qualify in that is not my case at all.
Okay.
I'll give some small.
No, my lord, I will just conclude. So they are stand, my lord, that this is a newly sanctioned post, my lord, the preliminary affidavit, my lord, that is still live, my lord. From there, they cannot go, my. And their records must reveal that it was, my lord, freshly sanctioned post or new post. The available records before your lordship show, my lord, possibly I do not know what is there in the records, my lord, that this had come over because of that, my lord, redistribution of post, my lord, possibly that is a better word, man.
No, Mr. Kakuti, the problem is that your records is only with regard to the marks. With,
Other records are, we annex it, record with proceedings with the Board of Governors.
no,
That's the
not
record.
proceeding. The other records, the file concerned while making the sanction of the post.
That is,
These things are not here.
Note sheets, my lord, all those things have to be there.
that is, we have annexed it, the proceedings with the Board of Governors. So
No, the note sheets
Creation of the post.
for the creation, not the creation of the.
Uh,
You are saying one vacancy came because of so and so, so and so.
that-
So that will be clear in your note sheets.
That probably, but the moment is approved.
So once that note sheet makes it clear that this is because of the from 50-50, from 75-25 to 50-50, And this, the one post that, the one vacancy that comes out is because of that, of the 50-50 ratio. That will be explained in the note sheets. Why are not producing those note sheets?
That we have explained the date, our explained it.
No, why are you so hesitant? to
No,
produce
no,
a
no,
report?
That I'll produce the note sheet in that case, what is the, how this process come. Otherwise, the proceedings would have covered up. These are our.
No, the proceedings that we have seen, that is the open document.
Moment it is
The
approved,
only thing is this vacancy of the second circular.
lordship,
I'm just saying vacancy.
yes.
Vacancy of the second circular. Was it a newly created post or was it because of the 50-50 ratio that this one post came? That will be there in the note sheets. Let us see the note sheet, then the whole picture will be very clear.
How it has come, with what issue.
And my lord, the citations that have been placed by my friend, my lord, that is not applicable to this case because I am not, my lord, relying on my selection in that subsequent this thing, my lord. So therefore, the facts are totally different, my Dinesh Chaudhary's case, my lord. There are 17, my lord.
That may not, that is court will consider.
Here the cleansing issue is this, my lord. If it was a newly sanctioned post, then my claim goes, my lord, they can go for this. Otherwise, we have to draw up someone for the panel, which is a procedure you are following in other cases, my lord. I've given documents, I have annexed, and the fresh case of Opurva Bhuya, my lord. Let him produce my records, how he has been appointed, whether he's drawn from the, my lord, wait panel, or he's a fresh appointee. Or my lord, selected candidate, I'm sorry, or a selected candidate. My lord.
Totally irrelevant, it's got nothing to do with these circular
My lord.
advertisements. It's not the issue here now. That will define issue altogether, it's not.
My lord, this is fairness, my lord. Because I am not on affidavit, my lord. I have come to know just now, my lord. If necessary, my lord, overnight I'll prepare an affidavit and I'll give it by the next day. You will get an affidavit.
In the absence of an affidavit, this
My
court is
lord.
unable to accept
Yes,
your
my lord, my lord,
submission
my lord.
also.
I understand, my lord.
Because
my lord,
if you
in
file
all fairness, my
if you
lord,
file an addition, then the other party
my
will
lord,
have a chance to rebut.
Yes.
to my lord, counter
Just
it.
making a
To
plain
counter
certificate,
counter
and
it,
then
my lord. I understand, my lord.
counter it will be
Yes,
difficult.
my lord. Only thing, my lord, in fairness, my lord, possibly, my lord, on relating to this Opurva Bhuya's case, my lord. Same interview, same circular, my lord, my learned senior friend. If my lord, if he, my lord, produces the record, that will cleanse the issue, my lord. I will not say anything, but I have made this my submission may be recorded, my lord. Or otherwise, I can file affidavit also. That they are proceeding. My lord, my case is that you are following the same procedure in other cases. Why?
Swami, I think we are expanding the scope of this.
Now, yes, my lord, he's out of pleading is my lord. So it will be never be in the business, my lord.
It will never
On
end.
after, my lord.
Okay, let them produce the records, my
After you
lord.
file your affidavit, they'll have to file a reply.
My lord, unnecessarily it will take
They'll have
time.
to counter after that, then what's the point of keeping it part?
My lord, let them produce
Let them
the.
you just produce the records. Then we'll,
Let's see how they proceed.
yes.
My lord, small reply, my lord, small reply. You are not.
You can reply the next.
Fine,
week. Let him produce a
Oh,
report.
my lord.
I'm
my
not
lord,
closing
my
this
lord, my
issue
lord,
now.
my lord,
I thought we can close this issue today.
my lord.
Actually, issue is very small, my lord. That part only, that is the case.
Then you keep this with you, otherwise it make and then produce it on the next day.
My lord, I have given the copies of the guidelines and all that.
Yeah,
That may be kept in there.
That guideline is not applicable to IIT-Z, my lord. That is already made a statement, my lord. You are known by the IIT authority. That is a
But they have
government-
not pointed out which is applicable to them, my lord, till now.
Because the IIT-Z is a autonomous body, my lord.
They don't have rules, they don't have to follow anything.
Counsel for the petition also heard. What is this central government MSA Gayan Leonard CJCA for respondent number 1. Mr. R.P. Kakuti, then a senior counsel, assisted by Mr. S. Sudacha. Then a counsel for respondent to seek Mr. T.J. Manda.
Respondent 7.
Assisted by MS P. Bhattacharya. Then a counsel for respondent number 7. Part in part, list the matter. When do you want?
My lord, March, my lord, second or third. Huh?
After the market, second, I will not take care.
Fifth of time only. Seven?
7 will be difficult.
My lord, my.
Then next week. No, not next week, man, March, March third week. 18 November. 18.
14th is a Thursday, my lord.
After 18th of March.
Then it has to be 19th. Then there has to be 19th, my lord, if it otherwise suits this code.
19th.
19th?
On which date, then the senior counsel for the respond number 2 to 6 shall produce all the relevant records in original.
Then note 6, man.
That's
Your
all
lordship,
records in
my
original.
lord, it has been clarified time and again, my lord, is not coming. Much obliged, my lord.
Item 7.
Make clear, your lord. This matter was heard on the last occasion for some time, my lord. During the course of the argument, my lord, your lordship had asked for the service rules, my lord. The service rules are here, my lord. I'll just place it. Before my lord produces the service rules, I would like to briefly narrate the facts, my lord, just to refresh my lord's memory, my lord. My lord, the petitioner, Vijayalakshmi Lashkar, she is currently serving well, she's currently serving in the post of Deputy General Manager, APDCL. Now, I'll only point out the relevant dates, my lords. My lords, while the petitioner was serving as the Assistant General Manager, my lords, on 9/06/2016, and a charge memo was issued against her, my lords, initiating disciplinary proceedings, my lord. But that is not relevant, just the date is relevant, my lord. That has been already settled. On 9/6/2016, lordship would kindly take down the date, my lords. The disciplinary proceeding was initiated because charge memo was issued to her, my lords. Now, while the disciplinary proceedings continued, my lords, on 27/01/2020, the disciplinary proceeding ended with an order of penalty, my lords, which my lords would find at page 41, the relevant portion, my lords, page 44A. Page 44, my lords. It's a typed copy, my lords.
Yes.
Imposes the penalty by stoppage of annual increment till 29/04/2024. That is the date of her superannuation, my lords. She's superannuating this month, my lords, on 29, she's superannuating, my lords, and will not be considered for promotion during continuation of such delay in the event of non-recovery of penalty in service tenure due to any other factor. The same or balance thereof will be recovered from admissible terminal benefits at one go. The disciplinary proceedings drawn up against charge sheet dated 9/6/16 against so-and-so is accordingly disposed of. Now, the penalty, my lords, consisted of three parts. First, my lords, that my annual increments would be stopped till the time I superannuate from service. That's the first penalty. And the second penalty, my lords, that till the time I retire, till the date when I retire, I will also not be considered for any promotion. So these were the main two penalties, my lord. The stoppage of increments till retirement and stoppage of all promotions also till retirement. Now, being aggrieved by the penalty, my lords, the petitioner preferred a writ petition, my lords, and the writ petition was disposed of in favor of the petitioner. Date kitna?
On
On 15/11/2022. My lord, 68 is the judgment of this honorable court. The relevant portion, my lord, would find at page 81. Paragraph 29 onward, my lords. Page 81.
Yes.
Page 29. My lord,
Para 29.
Para 29, page 81. On considering regulation 10.2A of the 1960 regulation, it is seen that the disciplinary authority can impose the penalty of stoppage of increment for a specific period on an employee found guilty of misconduct. However, the penalty imposed till retirement is stretching the provisions of the penalty that can be imposed to absurd lengths. A specific number of years should have been mentioned. Assuming a delinquent officer who is in his 30s or 40s is imposed with the penalty of stoppage of increment till his retirement, in the view of this court, stoppage of increment till retirement in such a case would be unreasonable, and the same is not contemplated to be included within the fold of regulation 10.2A3 of the 1960 regulation. Now, the next portion, this is important, my lord, to take note kindly, my lord. Also, there is no provision in the regulations barring consideration of an employee for promotion during continuation of such penalty. My lords, the penalty of stoppage of increment, although it was there in the regulations, but the regulations specifically said it has to be for a specified period. But it was made till retirement, that was interfered. And secondly, the honorable court had held, my lords, that the penalty of stopping promotion is not even contemplated by the discipline and appeal rules. And hence, it cannot be a penalty in a disciplinary proceeding. Besides the above, there is nothing in these pleadings to show that there is any money that is, well, this is not important. Next paragraph, my lords. In case of Vijay Singh versus state of Uttar Pradesh, the others report in so and so, the apex court has held that a punishment not provided in the rules cannot be imposed. Accordingly, the penalty of non-consideration of petitioner for promotion is not sustainable, as the same is not provided in the regulations. The said penalty is accordingly set aside, so and so, my lords, the matter was disposed of. Now, pursuant to this judgment and order, my lords, there are few intervening facts, my lord, I'll point out. Now, my lords, like I submitted, my lords, the disciplinary proceedings were issued on 9/6/2016, and it ended with the imposition of penalty on 27/01/2020. So during that period, from the starting of the disciplinary proceeding till the order of penalty, petitioner was in the post of assistant general manager. I am not aware whether there was any promotion which was made during that time. But the fact remains, my lords, I am not claiming promotion for that period. For the period when the show cause was served on me, till the time it resulted in the penalty. So during that time, I was in the same post. There was no promotion, there was no consideration for promotion, and there was no seal cover procedure, my lords. Thereafter, this judgment comes, Honorable High Court's judgment, wherein the other penalty of stoppage of promotion was set aside, and it was held, it is not provided in the rules. You cannot impose such a penalty. Thereafter, I made representations to the authority. I say in the representation, my lords, that pursuant to the order of penalty dated 27/01/2020, my juniors were promoted to 3 posts in the hierarchy, my lords. Whereas I was the assistant general manager, admittedly, that's an admitted fact, that's not denied by the parties, my lords. Admittedly, my lords, my junior, who was my junior, was promoted from the post of AGM to the next post of DGM, Deputy General Manager, then again to Deputy General Manager to General Manager, then again from General Manager to Chief General Manager. And I was in the post of Assistant General Manager. And it was because of this penalty, my lord, the stoppage of promotion, which was subsequently set aside by this Honorable Court, that I was not promoted. Now, after I make this representation on my lord's 2/1/2023, Lordship would kindly take 2/1/2023, page 87, my lord. Page 90 is the relevant portion. A modified penalty was passed, my lord, issued. Page 90, my lord. Page 90, the last paragraph would suffice, my lords. The undersigned being the disciplinary authority, after careful perusal of and considerations of all facts relevant, document judgments of the Honorable High Court and circumstances of the matter in exercise of the powers conferred upon Regulation 10 of the AACB so and so rule to meet the ends of justice, I do hereby award the penalty of stoppage of 3 annual increments with cumulative effect, with effect from July 2020 upon Shri Vijayalakshmi Loskar Datta. Now the initial order of penalty, where there was 2 penalties, my lord, increment and promotion, that was modified because of the judgment rendered by the Honorable Court, and it was modified to the extent that in case of, instead of these 2 penalties, the penalty would stand modified to stoppage of 3 increments for 3 years. Now this modification would obviously, my lords, operate from the date of the initial penalty, when the initial penalty was issued. That was on 27/01/2020. Now thereafter, my lords, after this order was issued, my lords, I approached the APDCL authorities by making a representation that since the penalty order has been modified, and the other part of the initial penalty, stoppage of promotion, has already been set aside by the Honorable Court, which has been affirmed by the department, I should be promoted on the date when my juniors were promoted. Rightfully so, my lords, because my juniors had 3 promotions and I was in the same post. Now thereafter, my lords, even after making the representation, no action was taken. And finally, my lords, on 7/9/2023, I was promoted from the post of AGM to Deputy General Manager, my lords. That is at page 97, my lords. 7/9/2023 is the date of my promotion. That is the date of my promotion, my lords, 7/9/2023. DGM. But my lords, to my despair, my lords, my juniors were promoted from the post of DGM to GM to CGM, but I was promoted to the post of DGM. Now, my lords, what the petitioner initially thought, which is later confirmed by the affidavit filed by the APDCL, I was not promoted, or I was not promoted at the same level of my juniors because of the fact that there was a penalty of stoppage of 3 increments for 3 years, and till the time that 3 years would run, till the time that penalty would run, the currency of the penalty, my lords, I cannot be promoted. Now that is the stand taken by the learned APDCL, my lord. And my lords, to justify that stand, my lords, there were 2 judgments placed, my lord, which I could gather, my lord, from the last date. One is the celebrated judgment of KV Janaki Raman, my lords, and the other is a judgment of the Supreme Court, Union of India versus K. Krishnan. Now, my lords, Janaki Raman was relied. In fact, just one paragraph was read, my lord, paragraph 29, if I'm not wrong, my lords. And as per Janaki Raman, Well, it's a mere reading of that paragraph, my lords, sans the other facts and the issues of the case would give a different meaning to that paragraph, my lords. I'll refer to that judgment, my lord. In fact, KV Janaki Raman is a judgment which would come in my aid, my lord. And the second judgment, my lord, which is Union of India and versus K. Krishnan, that was referred by the respondents to show that when a minor penalty of stoppage of increment someone is penalized with that penalty, my lords, during the currency of that penalty, you cannot be promoted. Now, my lords, to counter the submissions, my lords, my first submission would be, my lords, before even going into the other case laws and the laws, my lords, if that interpretation is to be followed, that during the currency of stoppage of increments, I won't be promoted, it would put me back to the same position again. Why I filed the initial writ petition? Because that penalty was there. The Honorable High Court had specifically set aside that penalty, the stoppage of promotion. Now, if they say that that stoppage of promotion would still be there, notwithstanding the fact that the court had set it aside, would put me back to the same position as before, my lord. That would also be against the judgment rendered by this Honorable Court, which has attained finality. No appeal has been preferred by the APDCL. Now they are trying to say that, okay, stoppage of increment, I have modified the penalty to only stoppage of increment for 3 years, but nonetheless, by some other way, I'll still not give you promotion for 3 years. Although that was set aside by this Honorable Court. Now, my lords, one more aspect, my lords, the law which the learned single judge has also referred, my lord, that a penalty which is not envisaged in the rules cannot be issued against a delinquent, my lord. It has to be circumscribed to the penalties provided in the rules. And the APDCL rules does not provide for a penalty which withholds the promotion of a employee, my lord. The other penalty, and as per the rules, regulation, withholding of increment was my lord's issued, was the petitioner was penalized, my lord. Now, coming to the judgments, I'll directly take my lords to the judgment. KV Janaki Raman, I'll hand it over to the tablet. Janaki.
You relied on Janaki?
Yes, my lord.
Yes.
It is there.
I think a copy was given.
Copy was given. I'm here. It is 91 for SCC.
Yes.
My lord, allow me to use the tablet, my lord.
Yes, yes.
My lord, taking the judgment, the issues, my lord, is there. My lord would find it at paragraph 8 of the judgment, my lord.
Yes.
The common questions involved in all these matters relate to what is service jurisprudence has come to be known as seal cover procedure. Concisely, the questions are: what is the date from which it can be said that the disciplinary proceedings are pending against an employee? What is the course to be adopted when the employee is held guilty of such proceedings if the guilt merits punishment other than that of dismissal? To what benefits an employee who is completely or partially exonerated is entitled, and from which date? The seal cover procedure is adopted when an employee is due to promotion, increment, etc. But disciplinary criminal proceedings are pending against him at the relevant time, and hence the findings of entitlement to the benefit are kept in a seal cover to be opened after proceedings in question are over. Hence the relevance and importance of the questions. The Union of India and other appellate authorities have by these appeals challenged the findings recorded by different benches of the tribunal in reply to one or other of all the aforesaid 3 questions in the decisions impugned therein. While recording its findings, the full bench of the tribunal has also struck down 2 provisions of the central government memorandum of January 30, 1982 on the subject, We may therefore refer to the said memorandum. This memorandum was in question, my lords. Memorandum issued by the central government, which was with some provisions of that memorandum was set aside by the Central Administrative Tribunal. Whereas this judgment is before L. Chandra Kumar, it has directly gone for appeal to the Supreme Court. So, my lord, that was the issue, my lord. Now, first thing my lord has noticed, this entire judgment revolves around the issue of seal cover procedure. But in my humble submission, in my case, seal cover procedure was never adopted because it was never required to be adopted, because during that period of time, from the time of the initiation, that is the serving of the charge memo, till the actual penalty, there was no promotions held. So the question of keeping my recommendation in a seal cover never arose. But nonetheless, my lord, how this judgment supports my case, I'll point it out, my lord. My lords would directly come to my lords, page number 115 of the judgment, my lords.
Yes.
Next page, my lord. Next page 116. Number Roman 3. After the findings are kept in a seal cover. Lordship has it, my lord. Page 116.
Yes.
But this is what I'm reading. This is the part of the office memorandum which was set aside by the Honorable Tribunal. Now, what does this office memorandum say? Well, I'll read it out. After the findings are kept in a seal cover by the Departmental Promotion Committee, subsequent DPCs, if any, held after the first DPC during the period of disciplinary court proceeding may be pending, will also consider the officer's case and record their findings, which will again be kept in seal cover in the above manner. Now, the next paragraph deals in a situation when a person is completely exonerated from the charges. Now, what happens, my lords, when a person is completely exonerated from the charges? In that case, my lords, that seal cover is open, and if he is entitled to be promoted, he is promoted from that day because he is exonerated completely. Lordship may skip this paragraph. This is not important. The next paragraph. What happens in case of a penalty? If any penalty is imposed on the officer as a result of disciplinary proceedings, or if he is found guilty in the court proceedings against him, the findings in the seal covers shall not be acted upon. My lord, the next line is very important, my lord. The officer's case for promotion may be considered in the usual manner by the next DPC. This is what I'm seeking, my lords. I'm not seeking promotion for the period when the disciplinary proceedings were pending till the time when I was issued the penalty, my lord. I'm praying for promotion pursuant to issuance of the penalty order, and which is there in this memorandum, my lord, which was set aside by the tribunal. What the Supreme Court says, my lord, we'll come to that, my lord. The officer's case for promotion may be considered in the usual manner by the next DPC, which meets in the normal course of after the conclusion of the disciplinary court proceedings. The existing instructions provide that in case where departmental disciplinary proceedings have been held under relevant disciplinary rules, warning, this is not important, my lords, what has been held by the Honorable Supreme Court, Lordship would come to paragraph 28 directly, my lord. With regard to that paragraph, my lords. Page 122, paragraph 28.
Yes.
The tribunal, my lord, has it, my lord? The tribunal has also struck down the following portion in the second subparagraph of clause 3 of paragraph 3, which reads as follows. I just read it, my lord. It was struck down by the tribunal. If any penalty is imposed on the officer as a result of disciplinary proceedings, or if he is found guilty in the court proceedings against him, the findings in the seal cover shall not be acted upon, and has directed that if the proceedings result in a penalty, the person concerned should be considered for promotion in a review DPC as on the original date in the light of the results of the seal cover, as also the imposition of penalty. His claim for promotion cannot be deferred for subsequent DPCs as provided in the instructions. It may be pointed out that the said subparagraph directs that the officer's case for promotion may be considered in the usual manner by the next DPC, which meets in the normal course after the conclusion of the disciplinary court proceeding. The tribunal has given a direction in question on the ground that such deferment of claim for promotion to subsequent DPCs amount to a double jeopardy, according to the tribunal, it not only violates 14 and 16 of the Constitution compared with other employees who are not at the verge of promotion when the disciplinary proceedings are initiated against him, but also offends the rule against double jeopardy contained in the Constitution. The tribunal has therefore held when an employee is visited with a penalty as a result of disciplinary proceedings, there should be a review DPC as on the date when the seal cover procedure was followed, and the review DPC should consider the findings. I'm sorry, Miller. In the seal cover, as also the penalty imposed. It is not clear to us why the tribunal wants to review DPC to consider the penalty imposed while considering the findings in the seal cover. If according to the tribunal not giving effect to findings in the seal cover, even when a penalty is imposed, amounts to double jeopardy. However, as we read the findings of the tribunal, it appears that the tribunal in no case wants the promotion of the officer to be deferred once the officer is visited with a penalty in the disciplinary proceedings, and the tribunal desires that the officer should be given promotion as per the findings of the seal cover. Now, paragraph 29, which was referred to by my learned friend, my lord. According to us, the tribunal has erred in holding that when an officer is found guilty in discharge of his duties, sorry, my lord, and imposition of penalty is all that is necessary to improve his conduct and to enforce discipline and ensure purity in administration. In the first instance, penalty short of dismissal will vary from reduction of rank to censure. We are sure that the tribunal has not intended that the promotion should be given to the officer from the original date when the penalty imparted is a reduction of rank. On principle, for the same reasons, the officer cannot be rewarded by promotion as a matter of course, even if the penalty order is other than that of reduction of rank. An employee has no right to promotion. He has only the right to be considered for promotion. The promotion to a post, more so to a selection post, depends upon several circumstances. To qualify for promotion, the least that is expected of an employee is to have an unblemished record. That is the minimum expected to ensure a clean and efficient administration and to protect public interest. An employee found guilty of misconduct cannot be placed on par with other employees, and his case has to be treated differently. There is therefore no discrimination when in the matter of promotion, he is treated differently. The least that is expected from any administration is that it does not reward an employee with promotion retrospectively from the date for his conduct before he is penalized in presenti, which is at the present time. Now reading the paragraph till here, my lords, in isolation would mean that in all cases, if you are awarded a penalty, you cannot be considered for promotion. If you read this paragraph in isolation. But this paragraph is in regard to the seal cover procedure. I'll read further, my lord, it will clarify. It will be, may I have a my lord, sip of water? When an employee is held guilty and penalized and therefore not promoted, my lord would mark it till the date on which he is penalized. The Supreme Court is referring to a matter when a person claims promotion in between the time when the charge memo was issued and he was penalized, in between that period. When an employee is held guilty and penalized and therefore not promoted, at least till the date on which he is penalized, he cannot be said to have been subjected to further penalty on that account. A denial of promotion is in such circumstances. Now, which are the circumstances? The circumstances where seal cover procedure has been adopted. In my case, no seal cover procedure has been adopted. It is not a penalty, but a necessary consequence of his conduct. In fact, while considering an employee for promotion, his whole record has to be taken into consideration. And if a promotion committee takes the penalties imposed upon the employee into consideration and denies him the promotion, such denial is not illegal and unjustified. If further, the promoting authority can take into consideration the penalty or penalties awarded to an employee in the past while considering his promotion and deny him promotion on that ground, it will be irrational to hold that it cannot take the penalty into consideration when it is imposed at a later date of the pendency of the proceedings, although it is for the conduct prior to the date the authority considers for promotion. For these reasons, we are of the view that the tribunal is not right in striking down the said portion of subparagraph after clause 3 of paragraph 3 of the said memorandum. We therefore set aside the finding. Now, subclause Roman 3 of numerical 3 was set aside by the tribunal. The Honorable Supreme Court had held, no, that was not correct. Now, again, just for a moment, my lord, to see what that subparagraph had said, my lord, lordship would come to page 116, my lord. Page 116, the third paragraph. Page 116, third paragraph. If any penalty is imposed on the officer as a result of disciplinary proceeding, or if he is found guilty in the court proceedings against him, the findings in the seal cover shall not be acted upon. Next line, my lord. The officer's case for promotion may be considered in the usual manner by the next DPC which meets in normal course after the conclusion of the disciplinary proceeding, which has been upheld by the Honorable Supreme Court in this KV Janaki Raman case. And that is the reason why I say, my lords, this case is in my favor. Looked at anyway, my lords. First, my lords, the case itself refers to a situation where a person's recommendation is kept in a seal cover. And that specific timing is the time when the DP is initially instituted, that is furnishing of the show cause notice, till the time he is penalized. In between that period, if there is any scope of promotion, a person's recommendation has to be kept in a seal cover. And if he's penalized, that seal cover will never be opened, but he'll be considered for promotion in the usual course in the next DPC. Now, I am not claiming that I should be promoted between that period. In fact, no promotions were held. And even if it was held, because of KV Janaki Raman, I would have been handicapped. I couldn't have claimed that promotion. But denying me of 3 promotions after the award of penalty is highly unjustified, my lord. My lords would again consider what would that amount to? That would amount to violation of the earlier order of the Honorable High Court, where in clear, unequivocal terms, it has been held that you cannot withhold the promotion of the petitioner, even without looking at Janaki Raman for a moment, man. To say, my lord, because that order is not challenged. Order is very clear that there were 2 penalties. I'm setting aside this penalty because that penalty itself is not in the regulation. So you cannot, in any case, withhold the promotion of the petitioner. Now, this is the first judgment which was placed by my learned friend, my lord. A reading of paragraph 29 in isolation, my lord. I was also very scared when I read it, my lord. It goes against me. But if you read if the entire judgment is read, my lord, it gives a different meaning. That is what I've understood. It favors my case. The office memorandum, which has been upheld itself, says that next promotion I have to be considered. Now, the second judgment, my lords, relied by my friend, my lords. Come to me. So, my lords, Union of India versus K. Krishnan. Union of India versus K. Krishnan, my lords. The judgment. Yes. I'll hand over a judgment.
I have.
My lord.
Supplementary.
My lord.
Supplementary, isn't it?
That's mandatory supplementary.
My lord, in this judgment, what had happened, my lord? Just to give a gist, my lord, before I take the judgment. A penalty akin to the present penalty was issued to a postal employee, my lord, that your increment would be stopped for 3 years. Now, during that period, he was not promoted. He approached the court that I am not promoted. It amounts to double jeopardy. The court had held that in case of the postal department, there is a specific regulation, regulation 157, if I'm not wrong, my lord, which clearly says, my lord, if there is any penalty which is with the currency of penalties going on, in that case, a employee cannot be promoted. But with the deepest respect, my lord, in APDCL, there is no such rule or regulation. Therefore, my lord, merely, it is not a rule of universal application that if a minor penalty is awarded, till the currency of the penalty, promotions will also not be given. Yes, my lord. In cases where it has been held, my lords, that you are not entitled to promotion, in all those cases, there were certain governing rules. Like postal has regulation 157, railways also has a rule. But there has to be a rule to curtail that, because my lord is aware, my lord's right to be considered for promotion is a fundamental right. And even in those cases, my lords, where there is a bar during the currency, even in those cases, not that you cannot be considered. You have to be considered, but it has to be given effect from the date when the penalty expires. Now, my lords, coming to the judgment, my lords, Union of India, K. Krishnan, my lords, just I'll paragraph 3. Short judgment, my lord. The Learned Counsel, my lord, has it, my lord?
Yes.
The Learned Counsel for the appellants has relied on the provisions of Rule 157 of the Post and Telegraph Manual, which inter alia provides that even where a competent authority considers a candidate fit for promotion in spite of punishment in a departmental proceeding, the promotion shall not be given effect during the currency of the penalty. So there was a specific set of rule. In our case, my lords, nothing has been pointed out in the affidavit that there is any rule where, my lords, during the currency, I'm not entitled to be promoted. Yes, if the rule is there, I ought to have challenged the rule, my lord. Next paragraph, my lord. We have considered the matter closely, and in our opinion, the view taken by the tribunal in both the impugned judgment and in the earlier decisions, holding that as a result of provision of Rule 157, forbidding the promotion of a state employee during the currency of the penalty results in a second punishment is not correct. Now, it had held during, in the facts and circumstances of that case, he was the delinquent employee was not granted relief because there was a provision, Rule 157 of the Postal Department, which in my humble submission, there is no rule or regulation akin to Rule 157, which the Postal Department has, my lord. Now, my lord, the petitioner, I would like to place a judgment, my lord, which squarely covers, my lord, the judgment of the Guwahati High Court.
Yeah.
Which squarely covers my case, my lord. I have handed it over on the last date, my lord. As by Honorable Justice S.N. Pukon. It's 1995 1 LLN 124. It's a 2-page judgment, my lord. Yes, my lord. My lords,
1 minute. I think just 1 page missing. Yes. Yes. Yes.
Just a moment.
Yes.
Yes, my lord. Paragraph 7. 7 is in the left-hand side column, my lord.
Mm.
It may be
One
stated.
minute.
My lord.
This reported in, this not reported.
It's reported, my lords. It's reported in, but here it's not there. It's GLR, my lord. I'll give the citation, my lord. Guwahati High.
Yes.
Paragraph 7. It may be stated that while forwarding the inquiry report, the letter dated 2nd March 93 was sent to the petitioner by the principal secretary informing him that the district council decided to inflict minor punishment subject to the approval of this court. The said proposed punishment is, this is important, all your increments of pay henceforth will be stopped and you will not be considered for any promotional post, if any. That was the proposed penalty which was challenged by the petitioner. Paragraph 9, my lord. The right-hand side column, same page, my lord. The first point urged by Shri Sharma is that the proposed punishment is bad in law, in as much as not only the increments of petitioner would be stopped for future, but he would be debarred from getting any promotion to the next higher post. According to Sri Das, withholding and stoppage are different, and therefore a punishment can be inflicted, drawing attention to Rule 8 of the Service and Discipline and Appeal Rule 64, which has been adopted by the District Council. Sri Das has urged that according to sub-rule 1 of Rule 8, the authority can impose one or more penalties. Therefore, there is no illegality according to Sri Das in the proposed punishment. Now, what was the punishment as per the rules, my lord? Clause 2 of Rule 7 of the said rules runs as follows: withholding of increments or promotion. So here, my lord, as per the 1964 rules, there was a provision as a minor penalty. You could either withhold the increment or promotion. And in the instant case, my lords, both promotion and increments were withheld, although only one could have been done. So what has been held, my lords? Therefore, the intention of the rule maker is very clear. The authority cannot impose punishment of withholding of increment and promotion. Only one punishment can be imposed, namely either withholding of increments or promotion. So the Honorable Court had held that only one penalty could have been imposed. Now again, Lordship, I have placed the rules, my lord, regulations, just to show what are the penalties, my lord. My lord would find AACB officers regulation, my lord.
Yes.
1960, I provided a copy, my lord, 1960. Page 10, my lord, I've marked the pages. Page 10.
Yes.
Without prejudice to the provisions of any law for the time being in force, any of the following penalties may be imposed on an officer found guilty of misconduct. Number 1, warning. 2, reprimand or censure. Number 3, stoppage of increment for a specified period. 4, fine. 5, reduction to a lower post or to a lower time scale, so and so. 6 is compulsory retirement. And 7 is termination, and 8 is dismissal, my lord. Now, my lord has seen there is no penalty which would allow the respondent authorities to withhold my 3 promotions, my lord. It's not there. So, my lords, by now contending that currency of penalty would also mean withholding of promotion, it's going back to the earlier position where I have challenged, and this court has said that no, you cannot impose 2 penalties. You can only impose withholding of increments, but not withholding of promotion. That has been held, and that has been not challenged by the APDCL till date, and it has attained finality. Now, my lords, the recourse left to APDCL would be now to rely on Janaki Raman first. My lord. I have read out Janaki Raman. Janaki Raman deals with a different scenario altogether. Janaki Raman was a case where there was a seal cover procedure. In my case, there was no seal cover procedure during the time, like I pointed out, my lord, when the charge memo was issued against me and when I was penalized. During that period, there was no promotion. So the question of seal cover proceeding does not arise at all. And nonetheless, my lord, I'm not claiming any promotion also. If there was any promotion, I'm not claiming any promotion during that time. Now, my lord would just imagine, my lord, I've been penalized. 3 increments have already been taken away, my lord, with cumulative effect. My juniors have now been promoted to the post of CGM. And in 2023, my lord, I've been promoted to DGM. I still have, my lord, three more, two positions left, my lord, to reach CGM. It is the reason behind it, because of the first penalty, which said my promotions would be stopped. This honorable court interfered with that penalty. Honorable court had held that that penalty was illegal, not sustainable in law. And thereafter, they modified their penalty. Now, a clear reading of the modified penalty, which I have read, it does not speak about stoppage of any promotion. Now, thereafter, they come up with this contention that during the currency, you cannot be promoted. Where is that law? Where is that rule? Where is that rule? My lords, in the other cases which has been pointed out, subject to any other cases which I'm not aware of, in all such cases, my lord, there were rules, there were regulations to that effect where, my lord, the promotions, in some rules, they were during the currency of the minor penalty, you cannot be promoted.
But that rule is absent here. There's no such rule. And in any case, I would have understood one promotion. My 3 promotions, my lord, I ought to have been a BGM in the year 2020. Now, I have also produced the other regulation, my lord, which provides for promotion of the employees. Like I said the other day, the promotion is on the basis of seniority. The zone of consideration would be on the basis of seniority, and from the seniority, there will be merit cum seniority. A person would be selected. Now, the minimum period in the post of AGM is 5 years, which I've already completed in 2019. 2020, my juniors were promoted to the next higher post. I was there because of the litigation, that penalty was there. During that period, again, they were promoted to the next higher post, then again to the next higher post. And till date, my lords, although I have an order in my favor, I've been promoted in the year 2023 to the next higher post, whereas my other juniors are in the post of CGM. That is the case, my lord, in a nutshell, my lord.
What do you say on this 1995
My lord,
3 Supreme Court?
1995.
PSCC 270.
My lord, just give me a moment.
1995 PSCC
Number.
273.
No. 1995. Yes, my lord. Yes, Thiru. Thiru, my lords, again, I would come to that. Thiru is a case, my lords, where my lords would come to the effective portion at. Yes. In my humble submission, my lords, paragraph 6, they had.
Para 3,
Yes,
with the picture.
Yes. Para 3, I'll read it out. The only question is whether non-consideration of the respondent's promotion for the year 1983-84 is in accordance with law. The tribunal has found that having imposed the penalty of punishment of stoppage of 3 increments, promotion cannot be withheld on that ground, which otherwise amounts to double jeopardy offending Article 21 of the Constitution, and therefore is arbitrary exercise of power violating Article 14 with Article 16 of the Constitution. We find the reasoning of the tribunal to be not correct. The Honorable Supreme Court had held that the reasoning was not correct. And what was the reasons to come to that finding, my lords? The reason was, my lord would find it at paragraph 6, my lord.
Para 6.
Para 6. My lord, the same thing had happened, my lord. Perhaps that's what I've understood. The Honorable Supreme Court in this case, which was prior to Janaki Raman, has only referred to paragraph 29 without taking note of the other facts which I had pointed out. Now, my lords, I'll just read out para 6. A bench of 3 judges of this court in Union of India versus KV Janaki Raman, according to us, the tribunal has erred in holding that when an employee is found guilty.
Para 29 of
Para 29.
That is para 29 of.
Yes, the para 29, which I've already read, they have just quoted para 29 of Janaki Raman without the facts and circumstances, my lord. In fact, this judgment also, my lords, if I may say, my lord, it's per inquirium and it's against Janaki Raman. They have just referred to one paragraph where there are some general statements that during promotion, but Janaki Raman was referring, in that circumstances of the case, was referring to a case where the matter was kept in the consideration was kept in a seal cover during that period. And by quoting this paragraph, in general, the Honorable Supreme Court in this matter has come to a finding that no promotion should be granted if a minor penalty has been awarded. But, my lords, with the deepest respect, my lords, this judgment, which is a 2-bench judgment, perhaps not the decision arrived in the judgment is not correct, my lord. It's against Janaki Raman. I have clearly pointed it out. I have read Janaki Raman again and again. It's not what Janaki Raman says. Janaki Raman says double jeopardy would not be applicable in a case where you seek promotion during the period where disciplinary proceedings are pending. It is not my case, my lord. My case is disciplinary proceedings are over. I have been penalized. Thereafter, why are you not considering me for the subsequent DPCs? my case for promotion. And Janaki Raman, I pointed out that paragraph itself was upheld, that you should be considered for the next DPC after the penalty.
Do you have any citations apart from the High Court?
Apart from the High Court, my lords. My lords, there's one more citation, my lords. Vijay Singh, my lords. 2012 5 SCC 242. Let us know, Vijay Singh. My lords, I'll hand over a copy, my lords. DOPT. My lords, the relevant portion. Paragraph 13, 14, and 15. And I'll just read paragraph 15, my lords. Imposing the punishment.
1 minute.
I'm so sorry, my lords. I'm so sorry.
Yes.
Paragraph 15, my lord. Imposing the punishment for a proved delinquency is regulated and controlled by statutory rules. Therefore, while performing quasi-judicial functions, the authority is not permitted to ignore the statutory rules under which punishment is to be imposed. The disciplinary authority is bound to give strict adherence to the said rules. Thus, the order of punishment being outside the purview of the statutory rules is a nullity and cannot be enforced against the appellant. This is, my lords, that judgment, my lords, because all other judgments where during the currency are not promoted, there is some provision, my lords. It's either postal or railway. For example, my lords, I'll give an office memorandum of the DOPT, my lords, which is not applicable in our case, my lords.
No, that's fine. That's fine. That part I have understood.
Yes.
Unless there's a provision in the rules.
Yes.
Do you have any other judgments apart from that, which helps you?
My lords, I can provide a written argument and I'll research for judgments and I can provide
No
it.
need
As
for
of now, my
no need
lords,
for written argument.
I'll get
facts
judgment. I'll get.
We can take up day after tomorrow. Also.
My lords.
Because you're retiring when?
29th, my lord.
So before that,
yes,
we have to finish
yes,
this.
yes. We have to finish. It's even if my lord is somehow not completed before my superannuation.
No, we'll make sure it's complete.
In any case, my lord, my promotion as of now will not prejudice anyone. I'm superannuating anyways. So if I'm promoted, no one will lose their seniority or no one will their chances of promotion will not get affected. With all due respect, my lord.
Just give me 1 or 2 citations that would,
there has to be a rule on that point, my lord.
No, on covering your case.
My lord.
If day after tomorrow is not sufficient, we can extend
day after tomorrow.
We can extend it to Friday. Even if it's not a hearing day, we can take it out.
Thursday, Friday. Not day after tomorrow, any day thereafter, my lord. Any day.
Any day.
Hello.
You give your
Friday, my lord. Friday. My lords are already heard. I'll place the judgment.
Basically nothing left. Just to hear the. Take up
23rd.
Yes. Is it okay?
My lord. Lordship will fix it up at 2, my lord.
Why?
Friday.
Miscellaneous day, my lord.
Miscellaneous day, that's why, man. Because there will be motions will come, my lord, on Friday.
Then we can take up on a hearing day. It's up to you.
As your lordship, please, I have got no difficulty. What I said.
Mandal and Council also heard Mr. M. Deka, Learned Standing Council ABDCS. 30th part, list for Friday hearing again on when? Give us
Friday, man. Friday, let us make an attempt, my judgment. Deep level.
Deep level.
Item 8 to 12.
I'll not take much time in this matter because we are not seeking for any regulation of service. Your Lordship will kindly keep it in mind. Not regulation of service. We are relying on order that has been passed by this Honorable Court, one, and also we are relying on an OM that has been issued by the government. And we are not asking the court that your Lordship will, our service is regular. We don't want. We are all master role worker working in the Water Resources Department since 1/4/1993 onwards. 93, 94, 95. There are batch of writ petition which I am appearing in some of the batch of writ petition. My learned friend Mr. Ken Chodri is also appearing in some of which my learned friend is assisting him. 8. I am appearing for 9. All the grievances are same. Almost same, all the grievances. My lord, on 2 documents I will place. Your Lordship will please keep in mind that we are not seeking for any regulation from this court. Why we will seek for regulation? Because it's not our case. Government also cannot regularize our service.
Your master role worker.
I will master role worker. Now master role worker working since from 1/4/1993 onwards. And we completed continuous 5 years of service from 1/4/1993. Now there is a, my lord will kindly see, I'll trouble your Lordship with 3900 of 2017. Kindly see that writ petition.
Are you relying on Opindas?
I'm sorry.
Opindas case?
Openness is when.
Open does it's a bit of different open does because open does is different. That also has been spelled out. That's a my lord 2017 4S 4 GLR 490 State of Assembly open does. That's I'm not relying on that. That is a difference, my lord, which will take care of the notification which issued by the state government. Kindly see, my lord, 3900 of 2017.
Next thing, Openness is applicable because we even to relying on the same master rule, but in this notification there is an exemption.
Yes. My lord, in open does, they are also relying on an OM, but this OM has got some exception. That is, we are saying the exemption is given, which we are relying on OM. If your Lordship kindly see the OM at page 264, 3900 of 2017, page 264, item number 9.
Item
9, this is, no? 9.
Two six four.
264.
Item number 3900.
3900. Why not 264?
item 9.
Item 9. There is a big writ petition because most of the there are writ petitioners, about 1,000, I think, writ petitioners.
It's 33900.
Yes,
Page 264 is the list of petitioners.
264. Item number 9 or 2?
It is 9. 3900.
3900.
3900.
39. Huh? Why not 264? तुम्हारा आते नहीं Oh, let's say you can believe that. I'll just help your Lordship once again. We'll correct it. We'll help it. No, let's see.
Anything
264. I'll just read it, and I'll just hand over that. Yes, sir. And I don't origination down delivery. No?
260.
Kindly see there's 264. Internal is 264, but 368 is given, I mean. Because 264 there is some implement application has been filed. That has been allowed, that is why 264. Kindly see,
You have
264. Only these two documents I will place it, my lord. I am not asking for any of the, your lordship will kindly look into it for what I am seeking for before this honorable court. 264 kindly be seen.
Yes.
So ban is 30th October 2001, office memorandum, subject ban on engagement of master worker, work choice employees engaged after 1/4/1993. My lord will kindly mark after 1/4/1993. Government has examined the question of continuation of the master role workers, work charge employees engaged after 1/4/1993 who have completed 5 years of continuous service pursuant to the order of the Honorable Guwahati High Court in WPC 48 of 2001, dated 24/1/2001. After a careful consideration, I think Upendas is related to this 481, a part of it. That's why your lordship was asking that whether you are relying. Now see kindly how exemption was granted next paragraph. After a careful consideration of all the aspects, it has been decided that the master role worker, work charge employees who were engaged after 1/4/1993 and completed 5 years of continuous service as on 24/1/2001 shall only continue in service in their respective capacity, subject to proper verification of their engagement by the respective appointing authority. All the appointing authority are hereby requested to ensure that no further engagement are made by them without prior approval of the SLAC and Finance Department. If any appointing authority makes any engagement in violation of the above directive, he will be personally responsible for payment of wages, salaries, and will be liable for departmental action as per rules. In implementing the above decision, the appointing authority are also to terminate service of those MRWC employees who have not completed 5 years of continuous service as on 24/1/2001. This partially modifies earlier decision of the government contained in para 1 dated 10/12/2000.
This is still in force.
Now, yes. Now what I am saying, my lord, there is an order of this court. Kindly see the order that has been passed. At page 253. 264, your lordship has seen. Kindly see the middle portion, middle pagination, middle. 253. This is an order passed by this court. My lord will kindly see judgment is 4/5/2010, WPC 560 of 2009. Having heard the learned counsel party, this court has passed an order on 8/4/2010, which reads inter alia thus. Considering the matter in its entirety and in the interest of justice, it is hereby made clear that unless otherwise directed by this court, there shall be no bar on the part of the state respondent to engage the present petitioner in the field work of department along with similarly situated other person if such engagement is legally made. It is further clarified that the engagement has been permitted by this court by its order dated 8/4/2010 shall not be in any manner which may come into conflict with the observation made and a direction given by a full bench of this court in Dichendranath Kalita versus State of Assam report in 2006 to GLT 654. That is in respect of a notification of 1995. 1995. As regards, now kindly see, as regards the claim of the petitioner that they have not been paid the dues for the period for which they have worked, it needs to be pointed out that the contention of petitioner that they have worked is disputed by respondent. For such a disputed question of fact, a proceeding of present nature, Article 227 of Constitution of India, is not the appropriate proceeding inasmuch as determination of such a question would require making a roving inquiry, adducing of evidence by the parties concerned. In such circumstances, as far as petitioner claim for non-payment of the dues are concerned, petitioners have to take recourse to appropriate provision of law for remedy of the grievances. if any proceeding is instituted by petitioner claiming payment of the alleged due, the observation made or finding recorded by the respondent in the inquiry report on 19/11/2008, so and so, shall not be binding on a petitioner, though the same may be relevant for respondent in order to sustain the findings in the matter. Now, when this order was passed by this court, now kindly see at page 255. 255 in the middle. Lordship got it? This is 12th of October 2010. And the order was passed on 4/5/2010 by this court. Now kindly see, my lord. If you kindly see 256. Kindly see 256. First 255, second paragraph. Again 255, second paragraph. Again, as per the office memorandum circular issued by various departments as referred to by the government, it is observed that most of this put emphasis on the ban on the engagement MR worker after 1/4/1993. However, as per the OM dated 30/10/2001 and subsequently published on so and so, it is stated MR worker who engaged after 1/4/1993 and completed 5 years of continuous service as on 24/1/2001 shall only continue in service in the respective capacity, subject to proper verification of the engagement by the respective authorities. Now, my lord, this is the whole crust of the matter. My lord, we are not asking. Now they are not working. Now they are not in the service. What we are saying, please verify it. Our party respective work, whether we have completed that period of 5 years from 1/4/1993 till 2001. You have to make an exercise. You have to verify. That's all. If you find that we are eligible, whenever this particular post are vacant, please accommodate us. That's what we are asking, my lord. That's what we are asking. We are not troubling your lordship that no, services should be regular. We are not saying. Please look into the order that has been passed by this court. Kindly see what is the report that has been issued by the department at page 255, which I am reading, my lord. This second paragraph, kindly see third paragraph. Now, as far the verdict is concerned, it is found difficult to interpret the proper meaning of specific mandate to be followed by this department. Honorable High Court, in its order dated 8/4/2010, stated there is no bar in engaging the petitioner if such engagement is legally made. Now, proper interpretation of this phrase, no bar, cannot be made at this end. The point of confusion is that whether the different government circle OM should be set aside as there is no bar. Now, if you will kindly turn to next page. In view of the above deliberation, it may come to a decision department may consider the matter of engagement of petitioner as per the verdict of this court if it is meant interpreted some of the confused word phrases of the verdict as below. Please further go down, see last paragraph. In addition, the above examination views on this honorable court verdict and different government order or office memorandum circular, the position of department on the matter is already stated in the counter affidavit in opposition filed in this honorable court. Further, an inquiry committee was constituted to make a detailed inquiry on the matter. Accordingly, the committee inquired the matter based on reports and hearing of the present concerning executive engineer and submitted report. Copy of the report is however enclosed here for ready reference further instruction order on the matter. Now, we file an additional affidavit bringing notice before the court that there is a committee which has been constituted and they have given a list. I have brought notice to the court. The list of those petitioners who are before this honorable court, who have been working after 1/4/1993, continuous for 5 years till 2001. What we are asking, we say that simply verify this list. Is a list which you have prepared, whether we fall under that OM or not. That's all what we want. So your lordship will kindly see these cases of 2017. Today we are in 2024. Simply we are asking for a direction before this court. Let the government verify it. Whatever. As
Where's
per
the list?
list I will show my lord. One second, I just trouble before the list. before the list, I'll just 259 kindly be seen. I'll show the list. 259. 259 kindly see, my lord. 259, that's a chief engineer water resource repent to a secretary. There's a third paragraph. On the other hand, there is a shortage of field staff in the department. So in view of the Honorable Court's order dated 5/4/2010 and towards implementation of the same, vacancy position of the field staffs SA so and so obtained from the respective division officer where the executive engineer responded in WPC number so ever. However, to fill up such post, prior approval sanction from the finance SU department is mandatory. In view of this, vacancy position as received from different division are forwarded to your honor and so for obtaining necessary sanction finance department. So the process of filling up the vacancy may be initiated legally and future problem in the instant case may be avoided. After obtaining sanction from the finance department prior to selection, petitioner would be informed through Assam so and so to submit the candidature if they like. So at least they should do this exercise. My lord will kindly say this is what the chief engineer has said. Please do this exercise. They have not done it. Now I have shown the OM, my lord. That's the OM which I have shown first. So what we are asking before this honorable court, they have prepared the list. Your lordship wanted to know that list. Where is that list? That list, additional affidavit we have brought. There are other lists also with the government because there are about 4,000, 4,000, more than 4,000. And no, at that relevant point of time. Kindly see the list, 379 ascending, you know. It started from 379. Lordship got it? 379. Kindly see on top, statement in respect of work charge, master role worker engaged after 1/4/1993 and completed 5 years of continuous service as on 24/1/2001 under different division which is prepared by Chief Engineer Guwahati. What, my lord, what you have to do? You see, please verify all this list.
What date is this?
This is,
This was filed in some report. We don't.
I don't know what report they have filed. They have filed some report. We try to get this particular, but report they will know what report has been filed. And this list was annexed along with the report. Their report is not
Is there a
available.
report? This list,
In the records will be there. Office records will reveal.
have you got the page 379
Yes, Lordship.
of the additional affidavit?
My prayers would have prayer.
I have got the link.
On what basis is this list made?
Lordship, this one, I have to take the instructions, Lordship. Before that, before my learned senior starts, I have sought for an adjournment. Since I have been engaged newly in this matter, so I prayed for some accommodation, Lordship. I've already said.
My lord, the problem is
my
that
learned
I
senior.
don't have eyes, so my lord, I fully agree. But let this matter be taken up by your lordship on Thursday. Because my lord, what we are asking, we're not troubling the court, neither my lord. Please examine, we are saying.
On
We
the
are not
basis of
asking.
the office member.
Yes, that's what you, if you feel, if you feel we are not entitled, pass an order, we are not entitled under law. If you are entitled, then please tell us. We know where we stand. Today also we don't know where we stand. There is a specific order passed by this court in 2000, your lordship was in 2010. There is an opinion given by the chief engineer. Finance has to look into it. This is a list which has been prepared. There are 4,000 employees. Today's status, they have to tell. My lord, what my proposal, what I am putting forward before this court, because my learned friend is there. Number one, these are the lists which have been prepared. They will verify it, whether we have been working from 1/4/1993 as per OM, continuous for 5 years till 2001. This is one. They will make their exercise. Whenever there is a vacant post which will occur, which will fall that preference has to be given to us because of the court's order. That's what I'm asking. Today, the position, we don't know whether this, they may say that position is not vacant whenever it occurs.
As per the affidavit which has been filed by the Water Resource Department on 3/8/2017, in paragraph number 4, paragraph 4, it has been categorically stated that, may I read, Lordship? It is specifically stated that none of the petitioners was ever engaged as master role worker stroke work charge employees under any divisions of the Water Resource Department.
So that's why I'm saying, why not you verify?
Yes, that's all.
This list.
Correct,
which you-
right.
Are your names here?
Yes. My name is there. Few of another list they have prepared, which we are not holding those lists. So those lists which are before them, they have denied here. Very well, my lord. Let them say that we don't fall under the category of OM. Finished. That's the end of the matter.
Lordship,
How
after
much
that-
time it will require?
After that, it has been stated that in 2008, Water Resource Department formed a committee to examine the records of the master role workers engaged after 1/4/1993 and completed 5 years of service up to 2001 under different divisions of the Water Resources Department. Found that only 3 such workers are working in hydraulic division. Only
And what is this list? 379.
that we have to verify, Lordship. Sometime.
No, it's absolutely no problem. Well, Lordship, what I propose, subject to what my learned friend, this matter can be disposed of with the direction that this particular list which they have prepared, they will verify in terms of the order of 5/4/2010 and OM dated so and so. If they find that no, these particular are working, they'll give this, yes, these are working. So whenever the position vacancy arrives, they will consider all case. That's what we want, my lord. It can be disposed of with 1-page order, my lord.
Because in the affidavit, it has been stated that only 3 such workers were found to be working.
Well, what is this list?
That is what Lordship.
379.
That is
Can I
what have-
suggest one thing, my lord? My lord, your lordship, there's a very small issue over here. Let my learned friend he's seeking time. Let him take time till this Thursday. He'll come back and inform the court about the list.
At
And
least
this is
one week
what-
time, at least one
as
week
a
time,
one
because
page,
this
my lord.
this is a list containing the names of around more than 1,000 employees.
No, that is a different issue, but the
Yes.
person who has issued this list
Lordship,
on the basis of a report.
this list has to be verified.
It is your list.
Yes, Lordship, that I do agree.
You have verified and then issued this list. Correct?
But we have-
Anyway, okay, you
Your-
take
your-
some instruction, there's
Yes.
no issue on
Please,
that.
Yes,
let
yes.
the matter come Thursday. Your lordship is not giving a direction that regularize their service. Your lordship is not saying. Your lordship, at best, your lordship verify the list. Whether they are entitled to get the benefit of OM or not. That's all.
Lordship, I
My
will
lord, that
verify,
matter can come
Let
up.
this matter be come up on next Tuesday, Lord. At least week time. I am not praying for more.
Okay.
Your lordship has heard. Let it be part heard, my lord. Lordship has heard this matter. Why not? You have heard this matter. It's
Partner,
only, this is a matter of, my lord, your lordship is, I'm not troubling with a judgment also. Why I will trouble, my lord?
heard Mr. Didas, Leonard City Council, assisted by Mr.
RB Fukan.
R.D. Fukan, Leonard Council, for the petition in WC number
3900
Oh,
of 2007.
2007.
My learned friend also is appearing.
Number 8.
Also heard Mr. R.M. Dekar, Leonard Council, for the petition in WC 5823 of 2021. On request made by Mr.
Monday.
R.M. Das, Leonard Standing Council.
Water Resources.
Water Resources Department. After you get out, when do you ask?
Lordship, 20.
27.
Lordship, 27.
27.
Let it be heard further, my lord. Part
Okay, it's part.
Yes. And replay of this. And replay of this.
Timing item 4.
Wait, please, Your Lordship.
Yes.
Time. Lordship may give us a date. Because respondent is not here. I think he's probably stuck in another court.
Yes.
My lord, please, still in the midst of hearing, my lord. How do we fix a date perhaps?
Okay, heard MS G Goswami. Learned counsel for the petitioners. You are appearing on behalf of?
KB Watermelon, B Das,
On record,
APDC, my lord.
on request made on behalf of Mr. Bidas.
My lord, B Das,
Learner Standing Council,
my lord.
ABDCL.
Yes, my lord.
When do you want?
Next Thursday, Your Lordship, 29th. It's part heard, so it will not take that much time, Lordship.
29.
My lord.
That's part.
Obliged, Your Lordship.
Item 13.
29.
Perhaps not written before that or after 4th April. After 4th April.
April.
No.
February, 29th
February.
February. Yes,
Very
yes,
well.
29th February, Your Lordship.
29th
right?
February?
Yes.
Yeah.
Very well, madam. I'm not.
Obliged, Your Lordship.
Item 13.
May I please, Lordship? Yeah, unfortunately, my lord, the main file is not with me, my lord, today. But we have filed our affidavit and they have filed the affidavit reply also. And by order dated 11/8/23, my lord, the matter is been admitted. And matter is been admitted, my lord. 11/8/23. Rule of discipline. And record also call for mine.
Yes.
Also, there is a more recent order to 2nd of February, wherein this honorable court had given direction to other party to give the updated instruction law. 2nd of February. The case has also been discussed in detail.
Yes.
In this case, Your Lordship, the main point is that the departmental proceedings findings have not been furnished. And the respondent has also admitted in the affidavit in opposition, Your Lordship. And we have a recent judgment of 2020 wherein it has been
But then he does not have the brief.
I'll have to wait. A little more accommodation is needed. I
You are
take the
free?
instruction my lord, as per the last order.
Okay. Heard Mr.
J. Das.
J. Das on a counsel for the petition. On request made by Mr.
J.K. Parajuli,
J.K.
government advocate.
Parajuli, then the government. List the matter when?
2 weeks, my lord, each time may be.
Hmm?
2 weeks time may be given, my lord. Even record is also called for, my lord.
List the matter after 2 weeks.
The date may be fixed, Your Lordship.
To enable, okay, list the matter on. Okay, on 12th March. Instructions.
All right.
Item 16.
May it please, Your Lordship. Lordship, matter pertains to compassionate appointment.
Kandagar, today there's no time.
On 28, my lord.
Mr. Kandagar, the counsel for the petitioner also heard Mr. CS Hazarika, the government advocate. For the respondents, list the matter. When?
On 4th, my lord, 4th of March. In the meantime, my lord, my friend may be asked to file the affidavit. Till date, no affidavit.
Lordship, what has happened is that this case has become in front. I didn't want to argue all these things. His main prayer was that consider my case in DLC. I have got the DLC minus. His case has been considered, and for some reason, he's been rejected. So now he has to
I have
challenge.
not been.
I'll give that way. I'll give you a copy.
18.
In this case, my lord, I've got the instruction recently, my lord. I'll file the affidavit.
Okay, heard
Date may be fixed, my lord.
Mr.
RM Dekal.
RM Dekal and the counsel for the petition. Mr.
J.K. Parajuli.
Parajuli, government advocate submits that he has received instructions. And press for how much time? 2 weeks time to file contract. This on 11th?
My lord.
11th March.
11 March. Deeply obliged.
19.
May it please, Your Lordship.
Yeah. Who's on the other side?
The Government of Assam, Your Lordship.
Have you filed your affidavit?
No, my lord.
An affidavit is filed by
No.
respondent number 4.
There is 1 to 3, my lord, awaited, my lord. 6 time may be given, my lord, I'll file the affidavit.
May I pray, Your
I have
Lordship?
not get any instruction like that.
May I pray 2 weeks time, Your Lordship? 3 weeks will be long.
Heard Mr.
Dury.
Learned counsel for the petition. So one request made by Mr. So-and-so, learned governor advocate. 2 weeks time is allowed to enable him to receive instructions. List after 2 weeks,
May I pray for a fixed date, Your Lordship?
15th
Deep
March.
Item 24 orders.
Here, my lords, here, the petitioner is asking for the minimum of pay scale as per open DAS judgment, my lords. Here, the file is being processed. My lords, the department has asked for 3 weeks' time. Issue is, my lord, it's not just the petitioner, a list of 1,000 or more candidates have been sent all together, my lord. Because of which some time will be required to take a decision. So, inform the petitioner side also, lordship may grant us 3 weeks' time. In the meantime,
Date may be fixed, my lord.
Okay, heard Mr.
MS model.
Learned counsel for the petitioner. On request made by Mr. Jalal, learned counsel appearing on behalf of the solicitor.
Date may be fixed, my
You
lord.
want 3 weeks?
3 weeks, lordship.
18th March.
Obliged. 22 for hearing.
There's a border matter also, no?
My lord. My lord.
Completion matters pertaining.
Sorry.
Yes,
Okay.
yes, please.
Let this be taken up on 27 February, my lord. Coming.
Who's for the petitioner?
I am for the petitioner.
Heard Mr.
Yes, sir.
S.R. Rabal, learned counsel for. Okay, on request made by Mr. S.R. Rabal, learned counsel for petitioner. When?
27 February, my lord.
27th. Many cases are fixed on that. Anyway, 27th February.
After 27, my lord. Any? First week of March, my lord.
Next week is all full.
Lordship, as per
Anyway.
lordship's convenience.
If you want it, we can fix it. Let's see.
On 27th?
Let it be that. Let's
Let
see.
23.
Lordship, this matter has become infructuous.
Mr.
C. Sharma, Lordship.
C. Sharma, learned counsel for the petitioner submits that the matter has become infructuous. Mr.
RB Goswami, my lord.
R.B. Goswami, learned,
Corporation Department. For Miss MD Bora.
appearing on behalf of MS MD Bora, learned
Of Corporation
counsel, Cooperation Department, appears for the, okay. Standing counsel appears for the Cooperation Department. The petition is accordingly disposed of as infructuous. Yes.
Of this Lordship.
25. Item 25.
Yeah, appearing for the respondent,
For respondent, for Lordship, private respondent.
none appears for the petitioner. MS
P. Sharma, Lordship.
P. Sharma, learned counsel appears for the respondent number 4. And Mr. C.S. Hazarika, learned government advocate, appears for respondents. 3. Respond number 3. Stop. List up to 2 weeks.
28.
May I please, your Lordship?
Lord, kindly taking this matter some other day, my lord.
When do you want?
First week of March, my lord.
On request made by Mr.
A. Burman.
Barman, learned counsel for petitioner. List on 13th March.
My lord. Public.
1-3, Your Lordship.
Yeah.
Item 1 and 2. Pertaining to adjournments.
Am I audible?
Yes,
Am I audible, my lord?
yes.
My lord, this is review petition. Earlier,
Review of which judgment?
the order dated, my lord, 26/11/2014. In the review petition, my lord, earlier we had already filed one review petition by these similarly situated present applicants.
Hmm.
This order has been passed in one case, the order which are seeking review. This has been passed in one case between two private parties, wherein they have made an agreement by making some partition of some portion of land. But in their agreement, they have included those lands which are not included by their past. And
Where's the order?
my lord, it's in the review petition just next to the index.
Hmm?
After the index, my lord, in the
CM. Civil miscellaneous application.
yes, my lord.
203.
Yes, my lord. Yes, my lord. If your lordship may kindly see the operative portion, the ending, the last, the ninth, page number 9 of the impugned order.
Yes.
The second paragraph, my lord. It starts with the plot numbers 1 to 32. Have you got it, my lord?
Yes.
Here, my lord, the plot numbers 1 to 32 and 44 to 70 shall be covered by PD Pata number so and so. Here, the grievance of the present review petitioner is that, my lord, in this plot number between 44 to 70, their respective lands were situated within in this plot. But this order has been passed on the basis of the agreement between those parties in other case, without affording opportunity of being heard to the present review petitioners.
When was this order passed?
It was way back on 26/11/2014.
2014.
Yes, my lord. Before that, my lord, if I may take your lordship to one page number 82 of my review petition, page number 82. Annexure 6, page number 82.
Yes.
This is review petition number 4 of 2016. My lord, in this case, the review petitioner in this review petition number 4 of 2016, they were also included in the affected by the said order, which is under challenge. And your lordship had granted them liberty to approach civil court without the influence of the order. If this similar order can be granted to the present review petitioners, my lord.
How many days delay is there?
Delay is total. There are about there are 2,181 days, but excluding the period of this COVID period and all, it comes to 1,1091 days.
Notice has to go. Who appears for the other side?
State.
Yes, Lordship, I'm appearing for the state respondents.
Respondents 1 to
Respondent number 1 to 7.
and respondent 8, you'll have to take steps. Victor?
Yes, my lord.
8, 9, 10, 11, 12.
Hurt Mr. Victor.
Yes, my lord.
El Ralte. Legal counsel for the applicant. issue notice. MS,
H. Dalmal Somi, government advocate.
give us your spelling. H,
HLALMALSAWMI.
okay. Then the government advocate appeals for the opposite parties 1 to 7.
7. Yes.
Stop. Stop. Applicant to take steps for service of notice on the response number 8 by registered
8 to 12. 8 to 12.
8 to 12.
In the IA, my lord, please, Your Lordship may kindly come to page number 5 onwards. For the present application, yes.
Mhm.
Page number 6 and 7.
Okay. On the we did the take steps for service of notice on the respondents 8 to 12 by registered post AD within 1 week.
Yes, my lord.
List after 4 weeks.
All right.
Deeply obliged, my lord.
Deeply obliged.